Cold in here. Wow, it's really cold in here. Okay. I didn't put my Zoom on. Right, do I need to have the Zoom on?
I know Ms. Gomez was going to zoom in if it was
Oh, okay, then I'll put it on. Okay, just give me a minute. Thank you. I brought another box. I mean, like,
Vanessa told me.
on my nose. Oh.
See your face.
I guess.
Just put it,
Oh, she hasn't.
Okay, let's go on the record. State of Florida versus George Pino. Parties can announce, please.
Good afternoon, Your Honor, Laura Adams and Jonathan Forrest on behalf of the state.
Good afternoon, Judge. On behalf of Mr. Pino, who's waiving his presence today,
Right?
I'm accompanied by my law partner, Mark Shapiro, and Ron Molino. Morning, Judge. Today, Alexa Klein is with us.
Okay.
I should have said my name is Howard Sterling.
Okay, very good. Thank you. And it's no problem for Mr. Pino not to be here today because we are, and he's, of course, can be if he wished. We're just going to be conducting our charge conference. I want to go through the jury instructions, and thank you, everyone. You all sent me your proposed instructions, and I think really the meat of it will be for me to address the manslaughter instruction, the vessel homicide instruction, and the request for an instruction on the navigational rules. Okay.
Agreed.
So, you each have your copies of what you provided to me, correct? You have your copies of what...
To be clear, earlier, over the weekend, last weekend, we may have sent you.
Yes, but it's been updated.
Yes, what we did today was we sent you the correct Word version
Perfect.
of what we had sent you in a PDF. There was a mismatch. Now you have exactly what we intended you would have as of last week. Today we will have some additional requests to go over with you.
Okay.
So you should have, from our perspective, we propose doing it on the
I
computer.
have yours here,
Using paper?
I have the states here, and I have mine here. Okay, so perfect. Thank you for doing that. Okay.
And we also have the ability to put it on the screen if you want to read along with you. That's up to
Oh,
you.
that's okay. Sure. But as long as you all have copies, you can follow along as we're going through it. So I think, you know, just to... I'm just going to go page by page, and when we get to the instructions that we'll have further discussion on, we'll stop and we'll talk about it, okay? So, the introductory, which I would call page 1, is just the introduction to the final instructions. And if I don't hear any objections, I'm just going to put a check mark and say that it's clear. Okay? All right, so that's clear. And we go to what would be page 2, which would be statement of the charge, of the charges. And we'll have both crimes of manslaughter and vessel homicide. And there are no objections that I'm hearing. All right, so then we get to introduction to homicide. And the standard instructions, from the way I understand them, is this instruction, if there is a death or manslaughter, there's a manslaughter charge, I have to give the introduction to homicide with what would be excusable and definitions of excusable and justifiable homicide. So while it was crossed, it was X'd out in the defense filing. You all want to talk about that?
Sure. Would you like us to stand or can we remain seated?
You could sit, that's fine.
So, the state is proceeding, we believe, we're talking about manslaughter now?
Well, I'm talking about, again, yeah, it would be, well, and I'll ask to state this, for the introduction to homicide instruction, all right?
Yes,
That would be 7.1
Correct.
of the jury instructions. Now, it must be read in all murder and manslaughter cases. So I would not have vessel homicide in there and referred to anyway, because it's to be read in all murder and manslaughter cases under the rules.
Judge, I'm gonna double check because in any DUI manslaughter case,
Manslaughter, right. But I'm talking
Right.
about vessel homicide. I don't think I'm going to say vessel homicide. I think it's manslaughter is unlawful because you charge it as a DUI manslaughter, but what you have here is the vessel homicide is a separate, under a separate statute.
Sorry, Judge, did you say DUI?
I mean, I thought the state just said that it's not a, if anything, it would be a BUI, but we don't have a BUI charge. And again, I'm looking at my rules and the 2026, and it says read in all murder and manslaughter cases, and I don't.
the reason why, I'm gonna try to find a case for your honor, but the reason why I think it's important to read as to both of the homicide charges is because the excusable homicide instruction that the court would give as a part of the introduction to homicide, I think applies both to vehicular and vessel homicide, because not every death, whether it's by a vehicle or a vessel, is necessarily going to be criminal. It can wind up that it is an excusable homicide. So if we can hold off on that, I just want to see if I can find a case that substantiates that. But I think it's important that the jury understands that if they find that this was an excusable homicide, whether it's as to vessel homicide or to manslaughter, that the elements of excusable are applicable to any of those charges.
Okay, and I think the defense, I don't want to speak for you. It seems to me that your position is that you don't think it should be given at all,
No, I think, just give me 1 second.
because it was crossed out on your
Yeah, so-
pleadings.
So we agree that excusable homicide should be explained to the jury, but think that justifiable is not relevant to the case.
It may not be, Judge, but again, that goes along with the standard instructions, which is that the jury needs to be placed on notice that just because a death results, it's not always going to be criminal. For example, justifiable use of deadly force. Nobody's saying here that, obviously this is a self-defense case, but I think it's important for the jury to have context within which homicide charges are brought. And that's why I think the instructions for this instruction say it is to be read in all murder and manslaughter cases.
Well, I think that then the question is whether or not it's anything that could be waived. It may not be, I don't know if it is something that, I think it goes together with the entire introduction to homicide instructions. When you look under 7.1, yeah, it's part of the instruction, so I don't know of a case where part of it can be waived and part of it included. I think the way the instruction reads requires me to read the entire instruction on introduction to homicide in these two subparts.
So I don't understand why it would be read if this is not a case of, for example, self-defense or some other explanation. And I think it's just going to confuse the jury on the issues that are before it. Because justifiable homicide is actually an affirmative defense, I believe. So now we're raising it. It sort of implies that the defendant has to show justification in a case that has nothing to do with that.
But, Your Honor, like, if we were trying a case of, felony murder and there's no hint of any kind of self-defense in the case, the court would still be reading this instruction. It's not confusing. It's very easy to explain to the jury, and defense counsel and I can talk to the jurors about it, but it's very clear. It's to be read in all murder and manslaughter cases. And when it's called Introduction to Homicide, I think it's kind of self-evident that it's any time that one person is charged with causing the death of another. That's a homicide.
When the prosecutor is talking about, is that what the book says that it's supposed to be done, or the Supreme Court is saying it's supposed to be done? I'm not sure. But what is it that the jury is supposed to do with that instruction? When they're deliberating, what are they supposed to do with it? Why would they even refer to it? We're giving them information that is supposed to be useful to them. How is that information to be used in the jury room? When they're talking about, okay, what do we do with this justifiable homicide business? Why are they talking about that in there? And if they're not supposed to be talking about it, why are we telling them about it?
Okay, I have to reserve on that aspect. The rest of the instruction I would give.
What's the rest of it?
On introduction to homicide. I'm going to reserve right now because I just want to look up a few things, see if there's, any cases on that. Because the purpose of the instruction is also to give the jury a clear statement of the law, but also not to confuse the jury. The same reasoning applies, for example, when anyone's making a request for special instruction, or there are some requests here, and I'll get to that in a minute. Whether the instruction itself clearly explains the law, but if it's something that is particularly not applicable given the facts of the case, are we putting the jury in a situation where it might be confusing?
Yeah. So that I'll try to understand.
I've always I have to say, as a matter of, because it's in the same instruction, there's not two separate instructions, although they're highlighted as under different subsections of the statute. This is not a case of justifiable homicide.
Correct, and the way it's currently phrased, the very first page, end of the second paragraph, it says, after introducing the concept of justifiable use of deadly force, it says, if you find Luciana was killed by Pino, you will then consider the circumstances surrounding the killing in deciding if the killing was manslaughter or vessel homicide, or whether the killing was excusable homicide or resulted from the justifiable use of deadly force. Now, why are they going to be thinking about that at all? Why are we telling them?
I understand your point.
Good.
And I am going to give consideration to excising it out, because again, the instructions, they're the standard instructions, but also not to confuse the jury. Or maybe some modified instruction that, you know, this is not a case of, or reading the instruction and telling the jury this is not a case for you to consider any kind of justifiable homicide. But I think that makes it more confusing and brings up matters that are irrelevant for their consideration. So I'm going to think about that, okay? Excusable homicide, that will stay in.
And if I could address that one, because there may be some cause for confusion. So I'm reading the state's proposed instruction where it says the killing of a human being is excusable homicide and therefore lawful under any one of the following three circumstances.
Okay.
Okay. 2 and 3 do not apply in this case because this is not a heat of passion case and it's not sudden combat.
Okay.
So,
Well, again, I'm not going to get to the point where I'm then carving up what the standard instructions are. In argument, in your final arguments to the jury, you'll have a copy of the instructions, and it would be an opportunity to, if you felt it necessary, to just explain that there's no, you know, none of this applies. Something along.
so okay, so you understand my objection and you'll rule
I
on
do.
that. But let's
I do.
go back to number 1.
Okay.
When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. The phrase usual ordinary caution implies not negligent. That's ordinary caution, I believe. It's implying that something beyond that failure to, let me say that again, negligence would render the homicide unlawful. That is, that the person, Mr. Pino, did not exercise usual ordinary caution. That's, as I understand it,
Well,
negligence.
that's your argument in terms of a defense to, you know, whether the conduct rises to the level of culpable negligence.
I agree, that's my argument. I'm afraid that this jury instruction is suggesting that if he did not act with usual ordinary caution, he's guilty. The state has to prove that he did not act, they have to prove he acted culpably negligent or, in vessel homicide, reckless.
Right.
Right? And so the way paragraph 1 of the excusable homicide instruction reads, as I read it, is that it's a defense so long as he was doing a lawful act by lawful means with usual ordinary caution. Right? So he has to prove he was not
When
negligent.
it's committed by accident and misfortune.
Yes, but an accident can be mere negligence.
Yeah.
Right?
Okay.
Okay.
So I'm not sure what the issue is.
And let me just give it one more look. It's because mere negligence is not enough to convict.
Okay.
And this is implying that he has to be not negligent in order to benefit from excusable homicide. Am I right? Yeah, negligence is the failure to use ordinary caution.
Okay.
So unless I'm misreading it, I think what this is telling the jury is that to have the defense of excusable homicide, you must be acting with usual ordinary caution. That means you, Mr. Pino, must not be negligent to be excused. It's implying that if he was negligent, he's guilty.
No, but he's not, your theory of defense is not that he should be excused, but rather he wasn't culpably negligent and/or reckless.
Yes, but this instruction seems to say otherwise. It seems to say that excusal, meaning excusal requires that he use ordinary caution, which conflicts with the theory that the state has to prove culpable negligence or recklessness.
But aren't these affirmative defenses, reading in the context of what would be an affirmative defense?
I don't know, but it shouldn't be an affirmative defense. It's the state's burden to prove he acted with culpable negligence or recklessness. It's not our burden to prove that Mr. Pino
No, this
acted
is just, but in the definition of homicide, and where a homicide, when a death occurs in a homicide, okay, the individual accused would be excused from any kind of criminal liability if the killing was done by accident and misfortune while
not being negligent.
while using ordinary caution
That term, ordinary caution, means not negligent.
and without any unlawful intent. You have to have no unlawful intent.
So it's putting the burden on us, Mr. Pino, to prove he was acting with ordinary caution, meaning he was not negligent.
I don't think it shifts the burden.
Well, it says,
Your Honor, if I can just interject, this instruction comes straight from Florida Statute 782.03. So maybe the defense wants to look at that statute because this instruction just mirrors what the statute is. So I don't
No,
know if
it's exactly what is in the statute. Review that. I hear your argument that this instruction, your contention is, shifts the burden to the defense to do something, but I don't read it that way. Well, I understand what your point is. I don't read it that way. This is just, defining what homicide and what would be, again, I'm using the word excusable. It's in the definition, and that's the definition of what would be considered an excusable death. I don't think it shifts the burden or puts any responsibility.
and so maybe I should ask, what is an example of an excusable homicide that's not, let's say, a justifiable homicide?
An excusable homicide might be a person is driving their car down the street in a lawful manner, and a kid runs out in front of the car, and the person runs the kid over, and unfortunately the child dies. That would be considered an excusable homicide. If for some reason a prosecutor wanted to bring charges, then the defense would arguably be able to say, no, this is an excusable homicide because my client, this was an accident, this is misfortune, he was doing a lawful act by lawful means with ordinary caution without any unlawful intent. That's exactly what 782.03 envisions, and this statute, this instruction simply puts words to that statute.
If there's a presentation of an affirmative defense, there's no requirement on the defense to, there's still no requirement on the defense to present any affirmative evidence.
So if the court, hang on one second. Yeah, so our view is if the court is going to give us the choice between having that paragraph 1 and reject my suggestion that it should be modified, I would ask that no instruction be given on excusable homicide.
Okay, that's your request. All right, what's the state's position?
Well, the state's position, Your Honor, is that it has to be given because it's the law. 782.03 couldn't be more clear. And literally, if they don't want it to apply, that just seems, I can't understand why the defense wouldn't want an instruction that's supposed to be read in all homicide cases. It's introduction to homicide. I guess they think it's maybe not good for their client, but we're not going to stack the instructions to be pro-state or pro-defense. They're just supposed to acknowledge what the law is.
Right, as standard instructions. So under the circumstances, I'm required to give what would be standard instructions, okay, in every case. Whether this says, of course, in the introduction to homicide, it's a manslaughter, and that's why I brought up the question of how vessel homicide, because it doesn't say specifically, I mean, a death occurs, but manslaughter and the elements of manslaughter are different, right, than the vessel homicide. So that's why I said that I don't know whether or not I would be including vessel homicide in the instruction. I would say manslaughter is unlawful, a killing that was excusable or that was committed by justifiable use of deadly force is lawful. And then I go, because if you read the instruction, do you have the book in front of you?
No, but I can pull it up if you tell me where to look.
Yeah, it's 7.1. It's the 2026 standard instructions.
7.1.
So if you go through the 7.1 instruction, let it be read in all murder and manslaughter cases. Okay, there's a manslaughter charge here.
So I have to object, and just as a point of reference, in the 11th Circuit, I had argued a case that the pattern instructions were mistaken, and the case resulted in a reversal, a case called United States versus Tackalaw, and the standard instructions were then changed because they were wrong. I don't think that these instructions are that you must give them if they conflict with another instruction. So let's ask, how is the state going to use that instruction in its closing argument, and how is the jury supposed to use that phrase that we just talked about, where it says it's an excuse if the defendant is acting with ordinary caution. It implies that it's no excuse if he's acting negligently. And then, because that's what ordinary caution means.
No, but if the jury does not find something more than ordinary caution, then your client's not guilty.
Except that instruction seems to say otherwise. It seems to say he's only excused if he acts with ordinary caution.
There's other parts to that.
Well, then that's why I'm saying they conflict with each other.
I'm not sure I agree. But
Let's just hope the state doesn't argue in closing using that instruction and say, here it is right here. He's only excused if it's ordinary caution.
I would think that would be an improper argument.
Which is why I don't want the instruction submitted to the jury.
Okay. I hear what you're saying. So, for now, just to let you all know, while I ponder this, I'm inclined to give the introduction to homicide instruction. I'm considering whether or not I would excise out justifiable homicide, because under no circumstances do I see that even relevant to this case. And in terms of the definition and excusable homicide, at this point I'm inclined to give the instruction as it appears in the standard instructions. Your objections are noted, and I'm still deciding whether or not, and I'm really not inclined to give justifiable homicide. I just think that might be a cause of confusion, and unnecessary confusion for the jury, and I don't see at all how. I think it's worse to put the onus on either party to argue to the jury in closing, by the way, you see these are the instructions, but disregard this, rather than just not have it there. I just don't see how at all excusable homicide applies. So, I mean justifiable homicide. Okay? So, for now, excusable will stay in. I'm going to excise out justifiable homicide and then give the rest of the instruction. Okay.
Objection noted, Your Honor.
Let's go to the instruction on manslaughter. Okay, I'm going to find the defense. Here's your instructions.
So are you there, Judge?
I'm right here. Okay.
Actually, I was going to propose, if it's the same to you, to start with vessel homicide, since manslaughter is supposed to be the instruction that has additional burdens on the state. So we can first understand what vessel homicide means, and then the court would decide what additional burdens the state has to meet to go to manslaughter from vessel homicide. So that's
Okay. I hear what you're saying. I'm okay though, starting with the manslaughter. Like just going through the elements that need to be established. And because you have in the manslaughter, you have, and I understand why, you have included additional language that in terms of definitional type of language that you're going to ask me to instruct the jury on that are not part of the standard instruction.
That's right.
And the reason why I'm going to make an assumption is because there has to be more that needs to be shown in terms of culpability. It's a greater amount of evidence in terms of culpability. Culpable negligence is a greater burden, and in describing that, you don't have the same explanations provided in the vessel homicide.
So that's in theory correct, although, as I've indicated throughout the proceedings, there's, in my view, tremendous confusion, indeed vagueness, associated with these two different charges. I understand the Supreme Court of Florida in a case called McCreary, and then a subsequent case over dissenting justices' opinions. There's this, I would say, at a minimum, confusion over the differences. If nothing else, it's hopelessly vague, but we'll get to that. And so, yes, I agree with you with that caveat. It seems to me that, well, I guess we should start and then we'll go through manslaughter.
Let's work through it, okay?
So there is one issue I'd like to flag for you. So manslaughter apparently has multiple ways of prosecuting it. The statute itself, we can just pull it up. So we've been talking a lot throughout the trial about culpable negligence as one way to establish manslaughter.
Okay, so let's look at 7.7 under the standard instructions. Let's go ahead and look at that, okay?
Are you looking at 7.7 in the pattern?
Yes,
Okay.
2026 standard instructions.
Moment. Oh, thank you.
And if you notice there, there's some language there that it's fundamental error not to construct unjustifiable and excusable homicide in the absence of an express concession that the homicide was not excusable or justified.
That sounds to me like it can be waived,
Well,
so that it's not required to be given.
express concession, how I interpret that, right? Does the state have an objection to my excising out the portion of the instruction that I really think is raises unnecessary points that are not applicable in this case?
No, I don't mind.
Okay. So.
But I would object to not including excusable homicide.
Sorry?
I would object to not including excusable homicide.
Right. I'm
But if the
justifiable.
defense is affirmatively saying they do not want justifiable use of deadly force to be instructed, then, okay, that's fine with me.
Okay, so I consider that a sufficient express concession by both parties on that,
Unjustifiable use, yes.
unjustifiable. Okay, so,
Is the defense,
You agree on justifiable?
Yes, I agree on justifiable homicide.
okay, good.
and beyond that, because the defendant is not here,
I'm gonna have to readdress this with Mr. Pino present before I'll put everything in kind of the best final form, and we're gonna convene, I think probably 9:30 on Monday, and 9:45 even. I think, having that express concession. I'm gonna have duplicates prepared for either way, just because I'm neurotic like that. So in the event that Mr. Pino doesn't agree, then I have the instructions completed. I'd like to have them completed, and we're gonna complete our charge conference today, is my plan, all right? Whatever is outstanding, throughout the course of the weekend, you'll hear from me, and I'm going to have prepared what I consider to be the final instructions. I'll put anything else on the record, and so they should be available to you as you're giving your closing argument. The state's going to start, and I guess you'll reserve time for a rebuttal argument anyway.
I'm just wondering if it's possible that the defendant could at least join us by Zoom or something so that the defense can consult with their client. These are really fundamental issues that might be a little bit boring for people that aren't in law, but this is the crux of the case. I don't understand why
Well,
I think the court excused him. I didn't realize the court had done that, which of course is within Your Honor's discretion, but
Well, I don't think there would be, well,
I mean, this is absolutely a fundamental part of the proceeding.
it is absolutely a fundamental part of the proceeding, because I have to get his acknowledgement, and I guess I'm comfortable that I'm going to get an acknowledgement and agreement Monday morning.
I'm certain that Mr. Pino is going to rely on our advice on these issues, without a doubt.
Okay.
And if you'd like, Judge, today we can actually have him submit something in writing before Monday, if that would be helpful.
The problem is, Judge, that I'm quite confident that this defendant's attorneys have told him on multiple occasions to stop emoting during this trial, and he hasn't.
I'm sorry, I didn't hear
To
you.
stop emoting, to stop with the head nods and the head shakes and the gestures and all of that, and he has not stopped. So I know his attorneys are operating in good faith, but I don't know what to expect from this defendant on Monday.
Okay. Once we get to the conclusion of this charge conference, before I sign off, you can summon via Zoom your client,
Sure.
and at least I would get something verbal, as far as that's concerned, and then I'll follow up with it in person on Monday. Okay? All right. So let's get through the manslaughter charge.
Guys?
Number one, the two elements must be proven is the victim is dead, so Luciana Cristina Fernandez is dead, and number two, give as applicable, so there's several subparts. A, defendant intentionally committed an act or acts that caused the death of the victim. Now, you've taken that out.
Yes.
Okay.
We believe this case is about culpable negligence. That's the third prong, C. Charlie prong.
Okay,
And so A and B are not at issue in the case.
okay.
Judge, the information in count 1 alleges that the defendant did intentionally commit an act or acts and/or acted with culpable negligence. So that's why both prongs should be given to the jury. The court did not JOA on either prong.
I didn't.
No.
Okay.
So let me begin by renewing then on the A prong of manslaughter. And then we're going to, if the court is overruling that, then we're going to have to spend some time understanding the difference between the two because it's going to be complicated. But first, my motion is to judge judgment of acquittal on the A prong, intentionally committed an act or acts that caused the death of Lucy.
Which is what I heard yesterday, I think. That was part of...
That was part of it. And Your Honor had asked some provocative questions about that. And,
Oh, thank you. Okay.
well, many of your questions are provocative, but on that subject, it caught our attention because what is the act, what is the difference between A and C? Let's ask the question that way. You would ask the question, oh,
I mean, I think I understood our conversations and what I based, my ruling on. I denied the judgment of acquittal. The state charged this in the alternative, right? And/or it could be either. So manslaughter could be in their charging document. If they're able to prove manslaughter either by Mr. Pino intentionally committing an act or acts that caused the death of Ms. Fernandez, and/or the death of Ms. Fernandez was caused by the culpable negligence of Mr. Pino.
right.
Right. And so your question was, and part of the argument was, what is the act or acts, well, that caused the death? The defense position is hitting the marker was the act that caused the death.
Correct.
Okay.
Because absent the elision, there's no death.
Okay. Understand. And I'm not going to speak for the state, so I think I understood their argument was the act leading to the elision are the intentional acts that lead to the death, such as, Ms. Adams, I think you said, the change of course.
Right, we already litigated that, but yes.
Okay, so, and that's what the state argued would be the intentional act or acts that ultimately caused, that caused the death of Ms. Fernandez. Does that make sense?
Except that the change of course didn't cause the death. It was the elision that caused the death. I understood change of course is the culpable negligence, is putting it on a path towards an elision. It's not, it doesn't cause the death. So at the moment that he changed course, nobody died.
I can't charge the water with causing her death.
That what?
I can't charge the water with causing her death. I mean, we already litigated this. These are what are in the charging document. The court denied the JOA. This is an accurate statement of the law.
So let's go down that rabbit trail. What is the jury under 2A, the act or acts that caused the death? The state is saying now it's enough that he changed course.
I'm not saying that.
Okay, I'm not sure what then the act is that caused the death if it's not the elision. Because typically culpable negligence is the whole course of conduct that puts the passengers in peril, is what typically happens in culpable negligence, driving in a completely erratic way beyond the pale, and something happens, but it was not, it was no intention to crash in a culpable negligence case. If he intended to crash, if the driver intends to crash into the pole, if Mr. Pino intended to crash, let's say that a driver says, I think the Robalo can handle it. I'm going to hit the pole and prove that the Robalo is just as good as a Grady White, that other boat brand. What is the crime? He didn't intend to kill anyone. He thought it was going to survive the crash. He's guilty of culpable negligence if the state proves he's acting with such depravity that even though he doesn't intend to kill someone, that act of collision causes the death.
Doesn't it go to whether something is foreseeable given the conduct?
It would be foreseeable that someone could die if you allied with a marker at 47 miles per hour. So if the person intentionally allied with the marker at 47 miles an hour, that would be manslaughter. It could be murder if it was his intention to kill everybody. If it was suicidal and homicidal, that was his intention. The state's not contending that. There's no evidence of that he intended to kill anyone. The state may be contending, I thought they were contending he wasn't intending to hit the marker at all. That's what they've said before in this courtroom. So if he was not intending to hit the marker, and he was simply intending to go back to Ocean Reef, but because of his failure to act with sufficient care, he was reckless in the way he operated, he accidentally hit the marker, accidentally meaning he didn't intend to, then he's perhaps, that's where the state is pursuing subsection C as a theory of manslaughter. That's how I view the difference between A and C. A was an intention to strike the marker, although without intention to kill him. C is no intention to hit the marker, but driving in such a reckless, forgive me for using that word, culpably negligent manner that it was predictable if you drive blindfolded while drunk at a high speed, you're going to hit something, even if you don't intend to. The best example that I could come up with in my mind in a car, somebody's running away from the police at 90 miles an hour down the interstate. He doesn't want to crash. He's trying to get away. But you go 90 miles down the interstate in the opposite lane through traffic, there's a high probability you're going to crash and kill someone, even though that's not your intent. That's culpable negligence at a minimum, perhaps.
Well, if you, in your driving example, if you're driving on the wrong side of the road, okay, it's foreseeable, reasonably foreseeable, that someone's going to come up on the other side.
Right, and that's culpable negligence.
Okay.
That's different than
But you don't need to be driving at 80 miles an hour to do that, or, you know, weaving or...
You may be right about just how reckless one has to be, but in either scenario, it was not the driver's intention to have a crash. It was his intention to avoid.
Is it reasonably foreseeable that a crash would result if you stay on the left side of the road instead of the right side of the road?
It could be, but that would be culpable negligence, not under A, an intentional act that causes the death.
Okay.
The causation of the death is the impact.
Okay.
Driving on the wrong side of the road may or may not result in a crash, depending on who's there.
Okay.
So
So it's your position, the only applicable subsection would be C.
That's right.
Okay.
Well,
And,
reserving my objection, of course, that they haven't proven even that.
Okay.
But A appears not to even be the theory of the state that he was trying to hit the marker.
okay. Now, understanding it's charged, and I'm going to run back to the state on this. Oftentimes, you know, charged in the alternative, it seems that that's how it's charged. So, in terms of the evidence for intentionally committed an act or acts that caused the death of Ms. Fernandez. And one more time for me, the acts that caused the death beyond the actual impact.
Can I just incorporate the arguments that I made during both of the JOAs? I've already said them multiple times. The court has denied the JOA. The court has already found as a matter of law that the state has proven enough for it to go to the jury.
Right. In your argument, and again, defense finds distinguishing, and there's no way, apparently, from the defense argument to distinguish this is manslaughter because it was established X, Y, and Z under subsection A, or alternatively, how they've established under culpable negligence that it's a manslaughter. That's what they're gonna argue. And you're gonna argue A there's no application at all, and there's no culpable negligence. I think that's how it's going to work out.
Except that, yes, except that there needs to be some understanding of what the word act is under A, that if as a matter of law, the act doesn't cause death.
Well, here's the thing. If there was some requirement, at least from a legal perspective, from the court's requirement of how to instruct the jury on the law, okay, there'd be a definition, right? And there's no definition here, there's nothing provided by defining what the act is. What the act is, okay?
It has to be that which caused the death.
Okay.
Under A, the act has to have caused the death. That's the definition.
Right.
And so, maybe we should, if we move
How
down.
about this, if Mr. Pino, from the evidence, didn't change course, would there have been an elision? No.
You're saying at the 9-second mark, if he had stayed on the path before the 9-second mark?
I think before that, wasn't it? Wasn't there a change of course at like 30 something seconds?
I think the state's theory is that at about 9 seconds to impact, there was a change of course that put him on a collision course. That's the state's theory.
So that's the question, right? That's my question. If there was no change of course,
At 9 seconds, he would have
there would be
avoided.
no elision.
That's correct.
Okay, so I suspect what's going to be argued is that the act itself of changing course resulted in the elision.
Except,
Okay, we're gonna keep going back and forth on that. I certainly get your point. Over objection, I'm going to give subpart 2A and subpart, which would be C, but I'm going to call it B, because subpart B here does not apply. Okay?
We
Your
agree that-
objection is
we agree that B doesn't apply, preserving the objection is.
absolutely. Okay. Go to the next paragraph. Okay, I don't see any conflicts in what you've provided. Then the paragraph that starts with to convict of manslaughter. I think I would be taking out, let's see. I'd be taking out justifiable, okay?
Yes.
We agree to that, but here's where the conflict then arises
Okay.
with excusable homicide.
Okay. It says not merely negligent. So it's already in there. If Mr. Pino, if the jury finds Mr. Pino was merely negligent, then they can't convict him of manslaughter.
That should end it.
Okay.
There should not be the confusion about excusable homicide.
Okay. And that is consistent with the argument you've already made about excising out excusable harm, essentially not giving the definitions beyond the first paragraph definition on introduction of homicide.
That is correct. That is our
Gotcha.
position.
Okay.
And we would submit that there can be a combination of more than one negligent act. that would still be insufficient to convict. And to the extent that this is implying he can have one negligent act, as long as it's clear let me stop a second.
I would say an act or acts, but again, when I'm going through and looking at the standard instruction, and the point you're raising, and if I'm not agreeing with it, you've preserved, obviously, and whether right now I'm continuing to follow what the current standard instructions are. You're talking here, commit an act or acts that were not merely negligent.
I think the simpler way to read would be George Pino cannot be guilty of manslaughter by committing acts that were merely negligent.
Okay. Well, that's kind of an interesting point, right? Let's say there are multiple negligent acts, okay? Does it become the case that multiple negligent acts, maybe individually in and of themselves, would not rise to the level of the type of culpable negligence that would need to be proven for there to be a manslaughter conviction? But the cumulative nature of multiple negligent acts combine to establish the level of culpability necessary to establish culpable negligence in manslaughter.
I have not seen a case that says that you add up failure to act with ordinary care, that a combination of failures rises to the level of culpable negligence. I just haven't seen that case.
I'm just, this is kind of a
Yep.
mental exercise.
Because what we're getting back to is it one act or is it multiple acts? Is it the operation of the vessel as one act, or is it speed plus X plus Y plus Z, none of which per se rise to the level of culpable negligence?
Well, isn't that what a lot of the cases that when you're talking, the cases that you've cited?
Right.
It's that it's not, there's a combination of factors that led to the conclusion, at least for that jury that was affirmed on cases, but a combination of factors that would either support or not support the verdict.
Right, in many of those cases there were multiple acts and the courts of appeals said not enough.
Okay, right.
So that the combination of multiple failures of the defendant do not combine to reach the culpability.
Depending on what you look at the totality of the circumstances, right? You have to look at the totality of the circumstances. You can't just look at it in a vacuum. Each case is very fact specific.
Right, so the combination of conduct, I suppose, is either negligent or not. And if it's negligent, then is it culpably negligent, meaning it's not mere negligence, it's got to rise to the level of that willful, wanton, because by definition, mere negligence is not an affirmative decision one makes, it's a failure to exercise care. It's not a willful and wanton disregard. That's where we get into the higher level of, mens rea.
Mm-hmm.
Right? So I forgot my keys. I did a whole bunch of things where I was not paying attention, and I still didn't act with mens rea. It was just,
Well, again, depends on the circumstances that you place yourself in or that are created, right? So I think that's the whole point of one of the points of this case, isn't it?
so we could just go through we can do our sort of closing argument in deciding how to evaluate this, but ultimately the event that, as we've said already, the event that causes death is the elision. Anything short of that won't, as you pointed out, if he stayed on course at that speed with those life preservers, with everything else the state is focusing on, there's no death. So that's why I'm struggling with the theory that the state is advancing, and it can't be enough that the state is going to say the flares you should consider that he had expired flares on his boat in deciding whether he was acting with wantonness or willfulness in his operation of the motor vessel, that he forgot to update his flares, and you should consider that. It has nothing to do with the cause of death. Nothing. Zero. He doesn't use a kill switch. He could have been more careful. All of these arguments that the state is trying to advance, none of which contribute to the cause of death.
Okay. So what am I going on, act or acts?
We propose the language. If you're going to overrule it, then it just remains the pattern.
Any comment from the state?
Well, I just want to make sure of the standard instruction after Your Honor reads the two elements of manslaughter.
Mm-hmm.
Every person has a duty to react reasonably toward others. Are we in agreement with that sentence?
Yep. No, that paragraph, I don't think that there was any dispute.
I'm just, we're talking about a lot of different things. I'm just trying to narrow down. Are we in agreement with that first sentence? If so, then let's go to the next sentence if we're in agreement on that, because otherwise we'll be here until, really late trying to get standard instructions on two relatively simple counts of manslaughter and vessel homicide.
All right. I understood then in the first paragraph, the defense believes that it should just be a merely negligent act, and then not have anything about if the killing was either justifiable or excusable homicide, as I have previously instructed you. We agreed on taking out justifiable.
Agreed.
Over defense objection, I'm going to give the rest in terms of the standard. The next paragraph, to convict of manslaughter, it is not necessary for the state to prove that George Pino had an intent to cause death, only to commit an act that was not merely negligent. I'm taking out justified or excusable, and I'm going to leave in, again, the standard or excusable and which caused death. Okay? Go to the next page, where there's a definition of culpable negligence.
Judge, so the paragraph you just read
Yes.
begins with to convict of manslaughter. That paragraph, at least under the old instructions, made clear that that is a reference to the subsection A theory.
Correct.
Okay, so we object to that for the same reasons we object to
Correct.
the 2A theory. So we
Correct.
think that entire paragraph beginning with to convict of manslaughter, it is not necessary for the state to prove that George Pino had an intent to cause death, only an intent to commit an act that was not merely negligent, et cetera, et cetera.
Correct.
We object to that entire paragraph.
All right, very good. Let's look at the next one. Now, what the defense has requested is, do you have the defense?
Yes, Judge.
Okay. Requested that essentially I include what would be facts, or facts that the jury would have to find, in further impressing upon the jury that there has to be a showing of culpable negligence, not merely negligence. I think that's the way I read the paragraph you want to include. Correct?
That's correct.
Okay. All right. Any comment from the state?
Yes, Your Honor. The standard jury instruction does in fact define culpable negligence. The state's proposed instruction follows that standard instruction to the letter. And I would also point out that in the Stevens versus State case at 787 Southern 2nd 747, a 2001 Florida Supreme Court case, it indicates that in order to be entitled to a special jury instruction, the defendant must prove the special instruction was supported by the evidence, that the standard instruction did not adequately cover the theory of defense, and that the special instruction was a correct statement of the law and not misleading or confusing. And I think for the defense, where they kind of fall down is that the instruction of what culpable negligence is, and the definition that it is given, is a correct statement of the law, and I don't see that what the defense has added clarifies the law. I don't think that it's necessary based on the evidence, and if anything, I think it makes the instruction a lot more complicated than it needs to be.
So,
I'm okay, but that's the rest of it after the definition of culpable negligence, right?
Yes.
The paragraph before that, where the defense is proposing that I tell the jury they must determine whether the state has proven beyond a reasonable doubt that Mr. Pino's act.
Judge, I'm going to withdraw that paragraph to
Okay.
avoid confusion. So we're withdrawing the paragraph that
Okay,
begins with the
let's
phrase
go
in
then.
this case.
Then it would be, there'd be a definition of culpable negligence, okay, which is the defense is proposing that I include the word merely negligence on sentence 1.
I see it, Your Honor.
You see it, right?
Yes.
Okay. Any comment from the state?
Yes, I don't think that it's necessary because the standard instruction indicates that if there's a violation without any conscious intention to harm, that's negligence.
Right.
Culpable negligence.
No, hold on.
I don't think that
Including the word merely. Do you have any comment on that?
Yes, I object. There's no reason to inject that into a standard instruction when the standard instruction adequately informs the jury what the law is.
Okay. All right, I understand the request. I'm going to deny the request over objection. I take the word merely out because it's not part of the standard. I think the instruction correctly defines the law. And again, I think that's for argument that the defense can make, but I'm going to instruct the jury consistent in this paragraph with what the standard is. All right, then we get to the negligent act or omission must have been committed with an utter disregard for the safety of another. Culpable negligence is consciously doing an act or following a course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. So you both agree on that. There's been no change there.
Agreed, Your Honor.
Then, now in terms of the standard, that's the conclusion of the standard. What the defense has asked, I guess as part of it would be a special instruction, would be additional language and additional definition. Okay? And you're making a reference to 8.9, which is the proof of the crime of culpable negligence. So I guess the question is, it looks like for 784.05, which is the standard is 8.9, which is you're referencing. definition of culpable negligence seems to be a different, more expansive in the 8.9 instruction than 7.7 under manslaughter. Okay. So that's that first paragraph that you're asking in terms of the special instruction for me to include.
Judge, could you read the first sentence that you're referring to so I'm following along?
Okay, so you're asking me to include culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows, you know where I am now, right?
Yes.
Okay, and you're referring back to 784.05 under the standard instructions 8.9. All right, so let me ask the state. Your thoughts on that, which provides incorporates essentially 8.9 into 7.7, and under a different statute. So if you look at 784.05, all right, this is the culpable negligence, a second-degree misdemeanor. And culpable negligence is a lesser included offense, category 2, lesser included offense of manslaughter. So,
Judge, the reason why what I would suggest to the court is this. If the court looks at the instruction 7.7 for manslaughter,
yes,
at the bottom it says it was last amended on September 12th of 2025.
right,
If you look at the definition of culpable negligence under Florida statute 784.05, which is in 8.9,
yes,
it indicates that the last time it was amended was in 1985.
yes.
So I would submit to the court that the September 12th, 2025 instruction for manslaughter's culpable negligence definition is the proper one for the court to give.
Okay. I am going to give the 7.7. My question would be, though, when you look at under manslaughter, category 2 lesser.
Yes.
Okay. So category 2 lesser is culpable negligence.
However, the non-homicide lesser included offenses do not need to be given if the parties agree that causation is not in dispute and that the victim is dead. And that's from Carver v. State.
Do not have to be given, right, under Carver. And it was last amended in September of 2025, right? As you said, the manslaughter instruction.
They updated it actually like a week ago. Did we have the one for 7 days ago? Yeah. We have the dates on
So I guess the question is causation an issue? And whether the defense would be seeking culpable negligence as a category 2 lesser. So I think that's the question for the defense. So I'm going to give the standard 7.7. I'm not going to, that first paragraph at least, I'm not going to give that as part of a special instruction to 7.7. The question is going to be whether or not the defense believes it's appropriate for me to give a category 2 lesser of culpable negligence, but with the caveat that, but that's a non-homicide lesser. And so we have a homicide, so
Right.
it's not applicable. I just kind of talked in a circle, but since this is a homicide, the lesser doesn't apply.
I understand the principle. This is where it gets back to the issue if the state is focusing on acts which did not cause that did not cause the death. Our view is it's the elision, not these other, like speed, for example. They're claiming speed, that he accelerated. That's the culpably negligent act. And absent the elision, there's no death. So that's the rub. I also recall that culpable negligence, I think, is a lesser included offense, that the misdemeanor is a lesser included offense of vessel homicide.
Well, we'll get to that when we get to vessel homicide. Okay. So, over objection, I'm not going to give a special on paragraph 1 in the defense request, and then there is additional explanation that you cite to the Jackson case from 1958, and also to, it's the same, okay. Definition of the speed, it's about the operator drinking or not, or some degree under the influence. It's not proof of itself of culpable negligence, and the state must prove under Miller, 1954 case, that the act was not the result of a momentary lapse of memory, inattention, or mistake of judgment. Okay. All right, any response from the state?
Yes, Judge, I don't believe that those should be given.
Okay. All right. Beyond the fact that I do believe that the standard instructions are a correct statement of the law, I don't think it's appropriate, and I'm not going to give the additional language and case law citation in the jury instructions. I think that could be part of argument, if you wish to use that as part of argument. But in terms of the instructions are sufficient to define culpable negligence. And, so I'm not gonna give what's been requested.
To make sure that I've adequately explained, we weren't expecting you would put the case citations in the jury instructions.
No, I know that. You put the citations to support the additional explanatory language of what culpable negligence is, what it isn't, and to further enhance, I think that's the position of the defense, that the instruction given, the standard instruction is not sufficient.
That's right. I just wanted to make sure you knew where we sourced the language. So our
Of
request
course.
would be over, and I understand you've overruled it, that each sentence that we have submitted for as a proposed instruction be given to the jury individually and in combination or in combination with the other sentences. If there's any one sentence you think would be acceptable, we'll take it. But it sounds to me like the court is not going to give any one sentence or the combination of sentences. And so I think we've adequately preserved the objection,
Yes.
understanding we weren't asking you to give the jury the actual case.
No, I understood that was for me to know where the language comes from.
Thank you, Judge.
And appreciate that. The standard instructions, in fact, the state had noted, but they hadn't been amended as recently as September 12th, 2025. So,
Actually, Judge, I believe they were just amended 6 days ago on June 12th.
I'm sorry, I don't hear you.
His client is saying that it appears on our computer that while we've been in trial, the rules,
June 12th. The proposed
the instructions have been amended yet again.
standard.
Yeah, that's the reasonable doubt instruction. The reasonable doubt instruction was,
All of them.
yeah.
Almost every standard instruction that I'm downloading today has been amended on June 12th, 2026. So last week.
Okay, so why don't you print out, because the only one that I have that we got a copy of is reasonable doubt instruction with any substantive amendments that would impact our case. Is the reasonable doubt instruction, I have that as the updated instruction. I'm not sure if that was in your packet or not.
I think so.
Yeah, we have that. Thank you on that. But there were no amendments to manslaughter instruction or the other instructions. Okay. All right, so I took care of that in terms of the manslaughter instruction. Let's go ahead to the vehicular homicide instruction, okay? Excuse me, not vehicular. Vessel homicide, excuse me. All right.
Judge,
Sir?
just so that we're not confused, we understand that the instructions that we provided to the court were a standard proposed instruction,
Correct.
came from the pattern instruction.
8.9.
8.9 regarding culpable negligence. It's not clear to us when it was amended. We think it was amended recently, but in any event, you have the benefit of the language that we took from what was at least at some point in time the pattern instruction. And over our objection, the court is going to
Well, yes, a different subsection, which was 8.9. I understand. Okay. And Ms. Pino was not charged with culpable negligence. And that goes back to what I said, that it would be considered a category 2 lesser, but that's for non-homicide. So I don't see that it's applicable here. So let's go ahead and look at vessel homicide. All right. All right, to prove the crime of vessel homicide, which is 7.9.
So with vessel homicide, this will be a bit simpler because we did not propose any changes to the pattern, but we have proposed supplemental instructions.
Right, which I would consider as requested for special instruction, so the question is going to be back to whether the standard instruction sufficiently defines, is sufficient in its language and correct, and the standard adequately conveys the theory of defense. So, let's go ahead and look at it. I don't think you were proposing that I include a citation to the Lizardo case.
Correct.
You just put that in there for my information.
It happens to be in the pattern itself, by coincidence.
Yeah, no, it is.
I don't think the jury's ever heard of the case, so I don't think it matters.
All right, so let's state, why don't you pull up, please, if you would, the defense request after the definition of operate. There's a request for, let's see, there's about 2 pages of special instruction.
Well, I think they're great defense arguments, but I don't think that they should be given under the Stevens case because the actual standard definition is very clear about what recklessness is. The reckless requires the state to prove more than a failure to use ordinary care. It means in a willful or wanton disregard for the safety of persons or property, and then both willful and wanton are defined. And it just seems to me that what the defense has done is just taken a lot of different ways to try to, I don't know, put into jury instructions things which should be arguments. What should be the jury instructions is what adheres to the actual statutory definition. The way that case law has been decided or the way that judges have written certain appellate opinions does not transform those into instructions that should be given.
Okay. You have anything you want to tell me? I mean, I've read, you further define in terms of argument also, citing to an 11th Circuit case and Black's Law Dictionary what reckless means. And then the next paragraph, is, a request, I guess, in instructing the jury for me to elaborate on what the jurors' responsibilities are. You have anything you want to say about either of those paragraphs?
Nothing additional.
Okay, all right. I'm going to decline to include the special request, but they are included as part of the record in your special requested instruction.
And
Do you
speaking
have
of the,
you should have a clean copy and include that in part of the record?
so today we will file what we email to you so that everybody's operating under the same paper.
And then on Monday morning, just make a reminder that, just for purposes of the record, that your requested instructions are documented and included in the record, but they're not anything for the jury.
Understood.
Okay. Let's go to the next page, if you would, where there's further request for the court to further define what is sufficient for the state to be able to sustain a conviction for vessel homicide. Again, that first paragraph, I see this as, and again, you're giving me the citations to cases. It wouldn't be part of the request, but further explanation in the instructions, and I am going to find that the instruction given as the standard instructions are sufficient and sufficiently define what elements the jury would have to find for them to come to a conclusion that Mr. Pino was guilty of vessel homicide. And a lot of this I find to be argument, and certainly you can make these arguments, but I'm going to decline to give that as well, and we'll include that as part of the your special requested instructions.
May I turn the court's attention to just a couple more that are in here that I'd like the court to give additional attention to.
Sure.
So you just reviewed the page that begins with this sentence, neither carelessness nor ordinary negligence.
Correct.
That cites to Lizardo, it cites to Warehan, W-E-R-H-A-N, and it cites to Esposito, and I understand the court's overruled our request. Then the next one I'd like the court to look at with additional attention is the citation is Strakar versus State, where it reads, the state must prove that George Pino, quote, in an intentional, knowing, and purposeful manner was operating the vessel at the time of the incident in a manner demonstrating a conscious and intentional indifference to consequences and with knowledge that damage is likely to be done to persons or property. I'd also like the court to consider the instruction that we took from Santisteban versus State, S-A-N-T-I-S-T-E-B-A-N. And this one says, speed alone does not constitute reckless conduct unless the speed is shown to be grossly excessive. Let me stop there, Judge, because that's an important issue for this case, since the state is focusing on speed and there is no speed limit posted. We would argue that it creates a bit of a vagueness problem, not a bit, a serious vagueness problem for the operator of a vessel, because speed now becomes at the discretion of the law enforcement officer or the prosecutor handling the case as to what they personally think the speed limit should be under a particular condition. And the jury needs to know it's not even enough that the speed might be deemed excessive. Under those cases, it has to be grossly excessive.
Well, let me ask you, sorry to interrupt, how you, doesn't it depend again on the circumstances of what could be a grossly excessive speed under the circumstances?
Yeah.
Because a speed of 20 miles per hour under certain conditions could be considered grossly excessive under those circumstances. A speed of 80 miles an hour under the totality of the circumstances may not be considered grossly excessive. Does that make sense?
I agree with you. That's why the jury needs to know The speed has to be not just excessive, it has to be grossly
No, but I'm
excessive.
still using the word grossly. It could be grossly at 30 miles an hour, depending on the circumstances, the additional circumstances. I mean,
That's
would
fine.
you agree
can-
with that?
If you feel that it would be helpful to add that speed alone does not constitute reckless conduct unless the speed is shown to be grossly excessive under the circumstances,
Yeah.
I'm okay with that.
Okay, I'm not inclined to do that.
Oh.
I just brought it up for, our discussion.
Right, and the reason I'm addressing it is because the state is arguing the speed was excessive. The rule that was presented to the jury, the safe speed rule, implies that there is a particular threshold for safe speed above which a speed would be excessive. And yet that's still not enough to convict under the case law. It would have to be grossly excessive.
Okay.
And the jury needs to know excessive speed alone is not enough. It's got to be grossly excessive. And because there is no posted speed limit or any legislative finding on what is an appropriate speed, we're now turning this over to 6 people to decide what an appropriate speed would have been. But they need to know it's not enough that it's an inappropriate speed. It needs to be grossly excessive. Lizardo was the case where the driver was doing 83.9 miles down, I think, Calle, and that didn't give the driver enough time to avoid colliding with a car. And the court said even that speed, which was, I forget, 30-something miles above the speed limit, did not support a finding of vehicular homicide. So that's why we need to make sure the jury understands the speed by law needs to be grossly excessive to support a conviction.
Okay. Do you have anything you want to respond to?
Of course, I object to that. I don't think that that is a proper statement of the law because, first off, Lizardo's just said on these particular facts, and there weren't many facts other than there was only the speeding. We have a lot more than that here. And beyond that, the definitions of wanton and willful more than sufficiently cover the concepts that defense counsel is trying to somehow, have this court instruct the jury. The jury
I
is
don't
the one
think
that's
that
supposed to decide.
And I'm going to decline the request, to look at, speed, the weather conditions, this, that, the other thing. I don't think it's appropriate for me to include that as part of what would be the standard instructions. I think the instructions is given properly to find what the law is, and this is part of argument. So while I understand why you're requesting it, I'm going to decline to give that. And also there's something about, I think the next paragraph as well.
So the next
Alcohol.
the next paragraph, we just took a direct quote from a case. What we would like is either just an instruction that consumption of alcohol, absent impairment, does not constitute recklessness or culpable negligence. That's what we're requesting. Because obviously the state is presenting evidence of the 2 beers, and I assume they'll be arguing that that somehow is relevant to the analysis of recklessness and or culpable negligence. I think the jury's entitled to know that the courts of appeals, they don't need to know it came from there, but that the law allows alcohol to be consumed, and that the mere consumption of the alcohol, absent some impairment, does not establish recklessness or culpable negligence.
Okay. Anything to respond to?
I would object.
Okay. I am going to decline to give the special requested instruction, but again, it's included as part of the record. Okay. And I think that would, looking at simple inattentiveness, citing to the Esposito case, I think that was your next request.
That's right. So, inattentiveness is insufficient to establish reckless driving. That's what we're asking for. That is what we believe the state is going to argue caused the accident. Mr. Pino was not paying attention in those last 9 seconds as the vessel was approaching and then ultimately collided with the marker. And just as a small footnote, we were talking earlier, you were asking about how the boat with 9 seconds to impact made that veer southbound. 9 seconds later there was the impact, but roughly 1 second before impact there was another apparently data point drop. I believe the expert, Mr. Albert, said that there was some effort there was a change of course, that apparently the inference would be that Mr. Pino, with a second to go, realized the marker was there, tried to take evasive action, and was unable to avoid the marker. That's what I understood him to say.
Okay.
And so it's clear to me that the state's theory is that Mr. Pino was inattentive in the last 9 seconds. And the case law seems to be clear that lack of attention in and of itself is not sufficient to establish recklessness, much less culpable negligence. And so we'd like the court to instruct on that. It comes right from the case law. And so we would ask that the court give an instruction.
Okay. Do you have any comments on that?
Yes, Judge, I think it's a great argument for counsel to make, but it's not the law that the court should be giving.
Judge, may I ask this, isn't that what courts of appeals do? They write the law as it applies under facts similar to those that are before the trial courts. And so we know from all the cases, Lozada onward, many courts have said speed alone, unless it's grossly excessive, doesn't support recklessness or gross negligence. Alcohol consumption alone, absent impairment, does not support recklessness or culpable negligence. Mere inattentiveness does not support recklessness or culpable negligence. Those are principles of law. That's what the court is supposed to explain to the jury. How otherwise will they understand what to look for in the evidence, if not by instructing them that the law says those matters of evidence that have been presented to them under the law do not suffice. If you don't tell them that, you're leaving it to lawyers to tell them that. But the courts of appeals have said that when lawyers have tried to argue that, it's led to wrongful convictions. So I'm asking you to instruct the jury to avoid a wrongful conviction, as was the case in these 14 cases plus that we have cited to the court.
Understanding absolutely what your point is, and a number of the cases that are cited go back for many years, right?
That's right.
And so, staying in my lane, I'm not going to include language from beyond the standard instructions for further definition, because that's a different branch of government that's responsible for making those changes. And so in these cases, whatever efforts are made, and you see amendments all the time. I think these issues, again, they're a good argument, and I suspect these are the arguments you're going to make, but I believe that the instructions as they exist sufficiently define what the law is, and those changes should be made, if they should be made at all, not by me.
So,
But I understand your point.
and I appreciate that you're willing to have the dialogue. This is why in the 11th Circuit they had to change the instruction, because the standard was inadequate to inform the jury of the law. That's why I believe there were 14 wrongful convictions, because the then instructions were insufficient to guide the jury. Jury instructions come from case law. That's where whoever writes those instructions, they get them from the judges who have ruled on cases.
Sure, and they change, and things change constantly.
And let me reveal my ignorance. Who actually writes the state jury instructions, if I may ask? Is it which
Well,
branch?
actually,
Committees that are designated by the Florida Supreme Court, they promulgate the rules and then the court adopts them.
So it is the judicial branch after
Well, it's
all.
not actually now. actually, the Florida Bar, the Florida Supreme Court does not engage in the creation of, make the committee recommendations. It goes through the Florida Bar Committee on jury instructions, and that's how.
Huh.
Yeah.
Well, then more of a reason not to simply accept them as the law, since the Florida Bar doesn't trump Your Honor's road by any standard of imagination. So I urge you to reconsider.
I appreciate that. But I'm gonna decline the invitation. But we'll have a copy of all of this, of course, in the record. And there are not a lot of vessel homicide cases. So I don't know where we're gonna go, right?
There's one other instruction that we proposed in this section based on the McCreary Supreme Court of Florida case that says if you find that George Pino is not guilty of vessel homicide, you must also find him not guilty of manslaughter by culpable negligence. It's either should come as a form of an instruction, because that is the law. If he's not guilty of vessel homicide, he can't be guilty of the greater offense of culpable negligence.
Well, I want to ask the state about that because, that's a point we had already touched on, and whether or not, there would be potential for an inconsistent verdict.
So what I think the simplest way to do it is that the jury shouldn't even deliberate on manslaughter unless they have first found that he is guilty of reckless driving, i.e. vessel homicide. They don't even get to it. So what I would propose is that the court instruct you first must decide if the state has proven count 2. If they haven't, then you find him not guilty and your deliberations have come to an end. There's nothing
It
to go
sounds
to.
like the instructions in a capital case.
I've never done one.
If you don't find an aggravator, you're done in terms of in second phase. Jury doesn't find unanimously an aggravator exists in a capital case. They do not proceed and the sentence is life. So I think what you're saying is something similar to that, not in the context of what would be an inconsistent verdict, but how the verdict forms would read. And so I am going to ask the state about that because I was curious about that issue, and when we get to the verdict forms, how they should read.
Judge, there was a case, it's State versus Perez. It's at 718 Southern 2nd, 912. It's a 1998 case out of the 5th District Court of Appeal. And in that case, the defendant was charged with...
You said the 5th District, right?
Yes, Your Honor.
And what year did you say? I'm sorry.
1998.
Thank you.
The defendant had been charged with 1 count of vehicular homicide and 1 count of reckless driving. The state charged them as 2 separate crimes as opposed to vehicular homicide with reckless as the lesser.
Okay.
And in that case, the jury came back guilty on vehicular homicide and not guilty on the reckless driving. And in that case, the court found that that was not an inconsistent...
Well, because they came back on the higher charge.
Right, but they found him not guilty of the lower charge.
Right.
And so the argument was, well, if they didn't find him guilty of reckless driving, then they could not have found him guilty of vehicular homicide.
Okay.
And the appellate court in that case said that, in point of fact, these are not truly inconsistent verdicts because there can always be the possibility that the jury just decided to agree on some kind of jury pardon or a compromise type of a verdict. Okay. So I don't think that the claim that the defense is making that if they don't find recklessness, they can't find culpable negligence is not supported by the law.
Well, okay, because is vessel homicide a necessarily lesser included of the manslaughter?
No, it's a category 2, and it depends on how the
Okay,
charges are
right,
pled.
okay. Okay.
And so the state, in this case, opted not to charge manslaughter with vessel homicide as a lesser. We opted to charge each count by itself.
I see, okay. All right.
I haven't read the case, we'll read it, maybe if we can take a few minutes, but I'm guessing that that's a case that deals with the principle of law that on appeal, the courts do not reverse convictions where there appears to have been an inconsistency in the verdict form, and the courts have said they'll ascribe that inconsistency to some jury nullification, some other reason other than an actual inconsistency. What we're proposing is to even avoid that possibility. I understand that if it happens, then the defense would lose on appeal on the principle that too bad, so sad. The jury likely just cut your client a break by...
Aren't there different elements though?
In this case, the theory of prosecution is that the manslaughter was committed with a vessel. So I don't see any other theory of manslaughter other than it was committed, it's vessel homicide plus a greater level of mens rea. That's what the McCreary case said in the Supreme Court of Florida. Specifically said that vehicular, not vessel, but vehicular homicide is a lesser included of manslaughter.
Well, doesn't that go back to the way the state is charged as an alternate theory? It's not just by culpable negligence on the manslaughter?
I don't see why that...
Because McCreary, is it McCreary just a culpable negligence, manslaughter by culpable negligence charge?
So let's assume it was either act or culpable negligence, either 2A or 2C. If it's 2A and it was an intentional act to crash, that would be reckless per se. There is no doubt about that, right?
Okay.
If you do it intentionally, it's beyond reckless. So manslaughter, as I have an understanding of it, you've got culpable negligence and then you've got outright intent to... So it's just what they've pled is two different degrees of intent within the manslaughter, both of which are greater than reckless.
Yeah, well, why is it not a category 1 lesser?
I don't know. I haven't studied it, but I can.
Okay.
If you give me 5 minutes, I'm sure we can give you the answer.
Because this is going to go to also my verdict forms, our verdict forms, how I think it would be appropriate. And I mean, we have count 1, the manslaughter verdict form, and then we have count 2, the vessel homicide.
I'm sorry. Can you please repeat that?
The verdict forms. I don't have a draft of the verdict forms, but we.
I sent one to the court. I can send
did
one
you
to
send
Norman
them?
now.
I'm sorry.
Yes.
Why did I not print them out? Okay.
I'll send them to everybody again.
That's great. Francesca, can you? Where am I finding here? Can you send it to Carolina?
Yes.
Okay.
Yeah, absolutely.
What's that? No, I just need a copy from me. All right, I'm going to pass on the rest of this right now, so we can let's finish up the, what we have in terms of the instructions.
Forgive me, Judge. What are you going to pass on?
I'm going to pass on this question of whether I'm going to consider any addition to the instruction of whether, if the jury finds that Mr. Pino is not guilty of vessel homicide, that necessarily precludes the jury from coming back with a guilty finding on the manslaughter. So I'm going to pass on that for a minute, okay? Then you're making a request for my further explaining what ordinary negligence is. I'm taking this as a separate special instruction. Like
Yes.
apart from the vessel homicide, the language you included, apart from the manslaughter language that you included, this is now another separate special instruction request.
Yes, please.
Okay. That ordinary negligence is not sufficient for a criminal conviction. Okay.
That's the title of our section.
That's the title of the special instruction. Okay. And then I'll jump back.
To be clear, we're not asking you to put the title in front of the jury. It's just to guide your review. It's the page that is titled "Ordinary Negligence is not sufficient for criminal conviction."
Okay, so as a special instruction, you don't want a heading?
If you'll give it to us, we'll take it.
Okay.
Yeah.
All right. State, do you know where I am on this?
Yes, Judge.
Oh,
And I would object to that instruction, Your Honor, because the standard instructions talk about that recklessness is, requires the state to prove more than a failure to use ordinary care. So the jury instruction for vessel homicide, just like the jury instruction for manslaughter, makes it very clear that neither recklessness nor culpable negligence can be proven with simple negligence.
cannot be proven.
Correct.
Okay. I'm going to decline to give the additional special instruction on further explanation of that ordinary negligence is insufficient to support a criminal conviction.
Understood. And to be clear, we would ask for each sentence to be considered alone and in combination, or, let me rephrase.
Correct.
Each be considered alone. We prefer that they be given in combination, but we'll take as few or as many as the court will give us.
Look at criminal cases are different from civil trials. Any comment from the state?
Yes, one moment, please, Your Honor. Your Honor, that instruction is part of the instructions that are given at the commencement of a civil trial. And that instruction is from Florida Standard Jury Instructions for civil cases. I think the court has already gone over with the jury during jury selection that this is not a civil case. And it seemed to me that there was nobody on the jury that was confused about that.
All right. I'm not going to give that instruction, but it's preserved and is part of your record.
Thank you, Judge.
Oh,
Same, let me just have a standing statement
Yes,
that
of
I
course.
ask the court to consider each sentence
if I
alone.
decline to give it.
Sorry?
If I decline your request, it's still over your objection,
Right, and then I've asked you to consider each sentence alone.
correct? Yes, you have it paragraph by paragraph, so individually and cumulatively for the subsection on criminal cases are different from civil trials. I'm not going to give that. Failure to exercise every possible precaution does not constitute recklessness or culpable negligence. And then we have is this part of the civil jury instructions?
It is.
Where I got.
Okay,
the language
all right,
from.
yeah, okay, I'm just double checking here. All right, I'm going to decline to give the requested civil instruction on failure to exercise every possible precaution does not constitute recklessness or culpable negligence.
And Judge, the court would, I just want to remind the court that the state has introduced evidence of all the things that George Pino could have done, even if not required by rule or regulation. For example, he could have had passengers wear life-saving devices. That's going to be the next one. You know, he could have had them sit somewhere else on the boat. He could have had the flares that are not expired. That's going to be a theme throughout, I believe, of the closing argument.
I
And
think you're going to make objections that you think are appropriate, if that's part of the closing arguments. But how the state, this is only one page. Oh no, okay. How the state would tie that in to their burden will be part of their argument, and then you'll make objections you think are proper to that
Yes,
argument.
but unless the court sustains them and instructs, then I'm going to look like I'm making a frivolous objection. So if my objection is, you're expecting my
Well,
objection.
I might sustain and instruct. It really depends on how the argument is made, right?
Right, and so I anticipate the argument that they're going to make, for example, that none of the girls were wearing flotation devices, and then ask the jury to imagine maybe the decedent would have survived if she had a flotation device on. Perfect example. Not required by law, but the state's made that a feature of their case, and they're going to ask the jury to find the defendant guilty because he could have had her wear a flotation device, and had she worn one, we might not be here on a manslaughter.
I'm not sure that would be a proper argument.
That's why I'm asking the court now, rather than for us to have to interrupt the state to rule on that issue and properly instruct the jury or the state that that's not a proper argument.
Okay. Do you have anything you want to comment on?
I'm not sure I'm understanding what he says I shouldn't argue.
I think we're trying to kind of anticipate what closing arguments are going to be.
No, I understand that, but I'm not sure what he's saying that I can't say about a life jacket. I'm
Yeah.
certainly not going to ask them to convict him of these homicide charges because the girls on the boat were not wearing life jackets. I think, like many other factors in this case, that's a factor that the jury can take into account. There's evidence of it. I could
Take into account to determine what?
to determine if the defendant was either reckless and or culpably negligent.
Reckless in or culpably negligent in the operation of the vessel?
Yes, because he's got a vessel that has passengers on it, that if something terrible were to happen, they're not wearing life preservers.
Okay. So how is that
crash and you've got a baby that's not in a car seat and the baby dies, would the
Okay.
prosecution be prohibited from talking about the fact that the baby wasn't in a car seat?
No,
And,
So-
you know, the state's not even permitted in a situation like that to say, oh, well, he violated that law, so you convict. But it's a factor that goes into the mix, just like it's a factor if the defendant had alcohol on board. Just like it's a factor how fast he was going. It's a factor of how much weight was on his vessel, what direction he was heading, what speed he was traveling at. All those things, the conditions of his passengers that were, some of them, you know, by their own testimony, were at a minimum buzzed. I think all of those things are factors in the way that this vessel is being operated, because it's not just where you're steering, it's who you're steering and who you're endangering. That all factors into whether or not you're reckless. And the Martinez case, Judge, substantiates that, because in Martinez, whether somebody's consumed alcohol or not isn't in and of itself reckless operation of a motor vehicle. But in the Martinez case, the Third District Court of Appeals said whether somebody had alcohol on board is a factor. It had nothing to do with the driving, but it had to do with the overall factual scenario that was taking place. And so if they can find that a person's consumption of alcohol, even if the state can't prove it was an unlawful amount, that's still a factor that the jury can take into consideration.
in determining whether or not the operation was reckless.
Correct, in a vehicular homicide case. So if we just transfer that onto the water, if one of the factors might have been that he consumed alcohol, okay, the third says that's okay. So let's look at other things that happened that endangered other people.
Well, don't you look to the actions of Mr. Pino, or the inaction of Mr. Pino, right?
Yes, and he's the
So
captain
the
of
inaction of Mr. Pino in not requiring the girls to wear life jackets.
He required them to sit down when he started going faster. He obviously recognized that things were not going to be as safe once he started moving at a faster rate of speed. I'm not saying he's guilty because he didn't make them wear life jackets. I know there's no law that requires it, and that was made clear to the jury. But it's a factor, and I, feel like when we were litigating the sworn motion to dismiss, the court seemed to indicate by Your Honor's ruling that the court was understanding the state's perspective that this isn't just as simple as a speed alone case. And as I argued in the first JOA, where there wasn't much argument about the second JOA, but in a situation like this, it's the state's position that, yes, of course this is reckless. If there weren't all those girls on the boat, if the defendant didn't even have any alcohol on board, if all he did was operate his vessel at that rate of speed in that direction, where unless he deviated course, he was going to slam into that channel marker, and he didn't do anything, if his wife had died, if she was the only one on the vessel, if Lucy was the only one on the vessel, he would be guilty of vessel homicide, no two ways about it. But you have all these added factors that endangered so many people that, to me, it didn't seem appropriate to only charge the vehicular homicide, because this isn't just reckless. This is something more than reckless. It's in the level of culpable negligence. And the jury can make a decision if they agree with my decision on how to charge it or not. But, in terms of the arguments that go into the mix of what's reckless, what's culpably negligent, those were arguments that were made that it seemed the court was sustaining when it denied the motion to dismiss and denied both of the JOAs.
Judge, may I just make sure that we're distinguishing between, because I think the state's conflating conduct that affects the operation of the vessel versus inaction that could, had it been done, might have mitigated the consequences of the elision. So a life preservers, by way of example, has absolutely nothing to do with whether there would be an elision or not.
But it has to do with whether or not there could be a potential for death, and remembering that the instruction is that the operation means an intentional, wanton means with a conscious and intentional difference to the consequences and with the knowledge that damage is likely to be done to persons or property. So the consequences of that recklessness also means if you're passengers.
If you're not prepared, or you have your passengers prepared for what would be a foreseeable consequence of the conduct, then that is, from the state's argument, ties into viable evidence that the jury can consider.
That is their position, and that's just not a correct statement of the law, because now that they're imposing upon Mr. Pino a duty of extraordinary care, the law doesn't require a life preserver. That's the simple example.
No, I don't think it's extraordinary. I don't see it. I'm not sure I agree with that. Given all of the circumstances, choosing a course of conduct, in this case in particular, to go from point A to point B, there were certain decisions made, and the jury can find or not find that these were conscious, intentional, not in an evil way, but in intentional conduct, that it would be foreseeable that death or great bodily harm could result because of the actions or inactions of Mr. Pino.
So,
I think that's what I understood the argument to be.
So, you can't compare consumption of alcohol, which, if enough of it is consumed, it would impair the driver and affect the operation of the vessel, to, for example, failing to go beyond what the law requires and force the passengers to wear a life preserver, by way of example. The law doesn't require it, you'll see that's our next instruction, but the state will argue to the jury, apparently, that he acted recklessly by not having the passengers all wear life preservers. Had he not alighted, the life preservers would have had no relevance to this at all. Of course.
Okay, I'm not sure I understand what you're saying. I'm not sure that I'm not going to speak for, and I've already heard just a general summary of what the argument is. I'm sure there's going to be much more to the state's argument, and we're not, previewing closing arguments here, but and again, whether or not, and there was evidence presented about there were enough life preservers and they weren't wearing them, okay, and the evidence, if I remember, Mr. Pino had the girl sit down knowing he was going to increase the speed of the vessel. I don't know if that was the evidence.
No, I think the testimony was at some point he asked the girls to sit down while they go underway, which is the prudent thing to do. Okay. I think that the officer, the lieutenant, agrees.
Okay.
I don't know what.
And I don't know what it has to do with the speed at all, or whether or not being prepared for what could be potential consequences to the actions that were taken.
Well, it also improves visibility, because if the girls are standing, they would obstruct his visibility.
Okay. So
there may be two reasons why it would be appropriate to have the girls seated.
I guess you could argue that, right?
But I'm okay with that.
Yeah.
That one doesn't bother me, right? He has everybody seated and he's being prudent. No one's going to say he's imprudent by having them be seated. That's not the issue. The issue is these other have an engine cutoff switch.
Okay.
Not required. No relationship between.
Okay. But that doesn't go to what was relevant evidence, and the weight or significance of whatever any of this evidence was That's part of the argument, right? That the jury doesn't, your position would be, well, what value does that have at all to how Mr. Pino was operating or failing to operate
Right.
the boat in an appropriate,
For some reason, in civil cases, the court gives this instruction.
okay.
You would think if it's appropriate in a civil case, it would certainly be appropriate in a criminal case.
Okay.
And that's all. So they're going to argue that Mr. Pino could have done many more things to improve safety. We all could do more. The law just doesn't require it, much less allow that a conviction stand based on the failure to do more than that which is required by law.
Okay. And, all right. I am not going to give the failure to exercise every possible precaution does not constitute recklessness or culpable negligence, and then the fact that the Florida law does not require persons to wear personal flotation devices on vessels more than 26 feet in length. That is argument, and I'm not going to give that instruction. And the engine cutoff switch, let me see here.
I think it's undisputed the law does not require an engine cutoff switch under these circumstances, just like the law doesn't require anyone to wear a personal flotation device.
Right.
Our recollection is you told the jury you would be instructing on this. That's our recollection.
I think that has to do with the navigational rules.
My recollection is not as good as my colleagues. They recall that there was a point in the examination where I was trying to extract these points of law, and the court told the jury that you would instruct on those points of law.
I think I would tell the jury that I would instruct on the law. I didn't know, I don't know if it meant that on whatever you were discussing, I was going to instruct on what you were discussing. I sustained an objection, and I'll instruct them on whatever the law is. What you're asking me to do, though, in terms of the instruction, is not an instruction that I'm going to give in this case in terms of a special instruction. Okay?
If we can find it, I'll let you know why that's our recollection, whether that changes your mind or not.
All right. And state if you see it, you see something, or you know something. If I made a statement to the jury with regard to the cutoff, it's cutoff switch, right?
Somebody called it a kill switch. Either way.
If I made a statement to the jury that I would be instructing them on what the law is on a kill switch or cutoff switch, I don't remember.
I seem to recall that on cross-examination, defense counsel asked Mr. Albert if there's any legal requirement to wear a kill switch, and I believe he said no. But we can double check the transcripts. But I think the jury already knows that that's not
The
a
jury
requirement.
knows that it's not a legal requirement.
Correct.
But whether I advise them that I would then instruct them,
I don't remember
I
that.
don't
but
remember. I'm not sure if it was in that context. Oftentimes I will say the court will instruct you on the
Right.
law, and I don't know if it was specific as to what the kill switch, what the laws on kill switch, what the laws on
Life jackets.
on life jackets. In terms of, I believe when we were discussing and I allowed evidence regarding the navigational rules, okay, I gave them an instruction over objection about the rules in general, that specifically advising them that a violation of any of those rules, individually or cumulatively, is not in and of itself evidence of a culpable negligence or recklessness. I think I gave them that instruction. over your objection, because I think the objection was that I should not have allowed any evidence of the navigational rules. I think that that's what occurred during the trial, which I allowed the state to introduce evidence of the navigational rules with that limiting instruction. And we're going to get to that in a minute, because then the state is asked as part of the final instructions for me to instruct the jury. And it's very similar to the instruction I had already given to the jury on how, if at all, they can consider the navigational rules. So I'll get to that in a minute, okay? In fact, I'm going to get to it right now, because this is the point to do it. Because next we would be talking about weighing the evidence. Okay, so.
Actually, Your Honor, the state had put in the jury instructions that I sent to everyone today that after Your Honor would instruct on the vessel homicide charge, that the next charge the state would be seeking was a charge on the navigational rules. And it's largely the same as what I had put forward previously.
And it has to, I think, and I agreed to instruct the jury over defense objection, and I think similarly in the final instructions there has to be a boundary or limiting instruction as to, so the jury is clear that a rule violation does not mean any kind of criminal culpability. It doesn't translate into either individually or cumulatively criminal culpability. So,
So on page 9 of the proposed instructions that I sent, I think is an accurate reflection of the case of Logan, which is at 592 Southern 2nd 295, because in that case, the defendant...
So I'm not going to read the rules specifically?
No, I understand that, Judge.
No, I'm
only
asking you. You're not
for this.
asking me to read the rule specifically.
No, if the court looks on page 9, the request from the state is for the following instruction. In the state of Florida, the law requires operators of vessels upon its waters to follow the navigational rules. However, a violation of these rules is not sufficient by itself to constitute culpable negligence or recklessness. In order for you to include a violation of any of the navigational rules in your deliberations, you must also find that such a violation was accompanied by a thoughtless disregard of the consequences or an indifference to the safety of others and caused or contributed to the cause of death of Luciana Cristina Fernandez.
All right, now you've already objected, but can you look at the language that's proposed and
objection to the first two sentences, but then I do object to the remainder of the paragraph, because that's now the court telling them how to use these rules in their deliberation. And if the court is not inclined to rely on Third District Court of Appeal and other courts of appeal case law when we propose instructions on how to guide deliberations on the ultimate elements in the case, and so too.
yeah, I'm going to modify the language a little bit there.
If the court would prefer that, and the defense would prefer in order for you to include a violation, if both parties, I know the defense is going to object under any circumstances, but if it makes it less objectionable to remove that final sentence, I'm happy to do that. And the court just advised that although the law requires operators to follow navigational rules, a violation of these rules is not sufficient by itself to constitute culpable negligence or recklessness. Sorry, then that's fine. I'll take that out.
I can just have a moment.
Because I think the less the better here, anyway, because it is a gray area, frankly. Again, not a standard instruction, and I need to make sure when I instruct the jury that there is a fair balance on, on not telling them how or whether they should, but just leave it as the simple explanation of they do not constitute culpable negligence or recklessness in and of themselves. So over the objection to giving a special instruction at all, I'm going to take out I'm just going to leave the first two sentences in that. Okay? Okay. Then I would have the reasonable doubt instruction. And that was just recently amended. In fact, we just got one additional amendment change that I've included. And this is June 12th. And I think yesterday also there was something that it's already been included. So let me look at this in the state's requested instructions. I think that you had included the amended instruction.
That's correct, Your Honor.
So I would request that the court include language from the 11th Circuit U.S. Court of Appeals pattern instruction. See, one moment, Your Honor.
Okay.
Forgive me, Your Honor, just one more second.
Okay.
So the 11th Circuit U.S. Court of Appeals instruction says proof beyond a reasonable doubt is proof so convincing that you would be willing to rely and act on it without hesitation in the most important of your own affairs. I would ask that that language be included in the instructions to this jury.
Okay. You have any comment?
This has been kind of laborious, so I'll just make a little half-hearted joke that maybe Mr. Shrevenick got off at the wrong exit, because we're to the west of I-95, not to the east in the federal courthouse building. But I mean, as much as, just as recently as last week, we've been given a new reasonable doubt instruction to be used in all Florida criminal cases. I don't see us bringing in the federal standard for a case like this.
I'm gonna decline the request, but you might wanna type that up also. And if you could mark it and include it in part of the record as well.
I think we have a court reporter who
That's fine.
heard what I said, but
Okay.
and she's nodding, so I think we're good, and I can just tell the court it's easily attainable at the 11th Circuit pattern jury instruction.
That's fine. All right. Then we're going to get to weighing the evidence. And again, this, as part of the standard, I took out, let's see, let me see, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Number 2. Number 3, was the witness honest and straightforward in answering the attorney's questions? Number 4, did the witness have some interest in how the case should be decided? Number 5, does the witness's testimony agree with the other testimony and other evidence in the case? Number 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify?
The state wants that in, it looks like the defense wants it.
Sorry?
The state wants that instruction to be included, it looks like the defense does not.
I'm not sure it has any application. I don't see what the application is to this case. I think that's typically when you have a cooperating witness, you know? Like a prisoner who's...
We have a witness that was offered money.
Sorry?
We did have a witness that testified for the defense that was offered money, so I think that that should be a factor that the jury can take into account.
Okay.
So that's why I'm asking for that
I
instruction
mean,
to be
well,
included.
didn't you have a paid expert?
Yeah, both sides did.
Okay. I
All right.
understand what the defense is saying in the context of more of like a cooperating witness. Over objection, I'm going to give number 6. And did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? I'm going to give that. I think that's it.
Just stick to me.
And I'm going to, I'll give the expert witness instruction. I don't see any changes in terms of, from the language of the standard.
I'm sorry, where are we now?
Page,
Expert
I've
witness?
just finished the, I finished number 7, and I renumbered them. And then whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. Okay? Then I move down to the law enforcement witnesses. Were there any female law enforcement witnesses that testified? Because it says his or her, so I'm just asking.
Oh, we can take out the her.
Okay. Expert witnesses, I'm gonna give that instruction. And let's see, his or her opinion. 'Cause didn't we have female expert?
Yes.
Okay, so it would be his or her. And the next paragraph, it's okay for a lawyer to talk to a witness. I don't see any changes there. And the last paragraph, there's been no changes there. So we'll leave that. Then the next instruction is defendant not testifying. Do you want both paragraphs?
Hold on to that. Judge, I would ask that in the second paragraph, second to last line, after the name George Pino, two words, did or, should be removed because in this case, Mr. Pino did not take the witness stand. So the last sentence would
Oh, I
read,
see what you're saying, okay,
No problem, Judge, we agree.
okay. Okay. You're also asking that I put your client's name where it says defendant.
it's fine, as you wish.
Any objection from the state? I would say against the defendant, George Pino.
Well, in the other places in the instructions where it called for us to use his name rather than the defendant,
Right.
it's listed in the
There's
same
a
way that it's
bracketed-
charged in the information. So
Yeah.
it'd be George I. Pino.
Yeah. So it's highlighted in the other standard instructions that you should actually put the specific name, but in this instruction,
It does not.
3.9, just so we're clear, and let me double check that.
If you look at this standard, it doesn't ask for the
Yeah,
defendant's
okay.
name in the way that it does like for the statement of the charge.
Right. All right, I'm gonna just, on the first sentence, just say defendant George Pino, then the rest of it will be the defendant. Put his name there, okay? Look at the next instruction, which is defendant's statements.
One moment, Your Honor.
I think that's the standard, and I think you agree with the standard from what I'm reading in your requested instructions.
Yes, Judge, I'm trying to process one other issue. 1 second.
Okay. Melissa, you okay? Need a break? You want to take a minute?
We're almost done, right?
I think we already wanted, do you need a,
I'm sorry. We're almost done. I'm good.
okay, whatever, okay.
Your Honor, we have a request that in proposed instruction 3.9B Bravo, defendant's statement.
3.9B,
Is that what it is? So mine says,
defendant's statements, yes, okay.
in the middle of the page, it has 2 factors to consider.
Yes,
We would propose a third one, and that is Mr. Pino's mental and physical condition at the time of the statement.
Your Honor, the state would object to that. The purpose of 3.9B is to ensure that the statement was freely and voluntarily made, not that it was also necessarily intelligently made,
okay,
or that it was made by a person, you know, that had a particular physical condition or non-condition. It talks about to make sure that it was freely and voluntarily made. That's the issue. There's no
okay,
allegation.
part of the
here.
argument, part of
They
the,
can argue.
part of your argument is gonna be, it wasn't freely or voluntarily made because Mr. Pino was suffering the effects of a medical, event, a concussion, or, right, okay. The instruction says, though, whether they were freely and voluntarily made. So, including but not limited to. So I am going to decline your request. But certainly that's goes into the argument of whether it was freely or voluntarily made. And other things that, you know, and you, you know, this is in the context of where you see these instructions is when there is a statement against interest, when there's a confession, when there's, so, yeah, I'm not going to add a third paragraph to the standard, but that'll be part of your argument as to why it was not freely and voluntarily made. Okay. Look at rules for deliberation. And I think we agree that since this is not a penalty phase, a capital case, that there were certain paragraphs that are taken out. Everything else, what I'm reading from the defense version and the state version look to be consistent.
Agreed, Your Honor.
And there are seven paragraphs that the jury should consider in the rules for deliberation. Let me know when you're ready.
I'm ready.
Okay. Cautionary instruction. I think it's consistent with the state and the defense with the standard instruction, and nothing, there were no special requested instructions. Verdict.
Not sure I understand.
There's no lesser, so that first paragraph, it is out on what would have been the standard because I'm not instructing them on any lesser, so I'm gonna take that paragraph. That was in your draft?
Yes, but.
All right, then I have the verdict form, which I'll go over in a minute. Let's just keep finishing up with the instructions here.
With regard to the verdict instruction,
Yes.
you have under consideration the issue that we raised earlier about that if the jury were to find Mr. Pino not guilty of vessel homicide, that would necessarily end the deliberations because vessel homicide is the lesser offense than manslaughter. So you still have that under consideration.
Right, so, and I think that if there's gonna be, if I'm gonna make any changes or amendments to the standard, it would be at this point, because I still haven't decided that yet. Okay? Okay.
And so the request for the, what I'll call the special verdict form regarding not having the jury deliberate on manslaughter if the jury has found that Mr. Pino is not guilty of vessel homicide, that would then affect what is now, I think, 3.12A alpha, single defendant, multiple count of informations.
Yes. I see, yes, I agree. If I'm going to add any language, it would impact that as well.
And then you'll see our next proposed instruction, 3.12D delta, legally interlocking counts.
Okay. All right. See, have you had a chance at all, because I don't know if you have, to look at the request on the 3.12 legally interlocking counts?
Yes, and it's not a correct statement of the law for a variety of reasons. First of all, even if the jury finds the defendant not guilty of vessel homicide, they still could find him guilty of manslaughter because, number one, they are not considered truly inconsistent under the Perez case, and number two, the state has charged the defendant with manslaughter under both the culpable negligence and intentional act theory. So telling the jury that they cannot find the defendant guilty of the crime of manslaughter if he is found not guilty of vehicular homicide is an inaccurate statement of the law.
Okay, so this actually then boils down to, when we go back to how the state charged the manslaughter with alternative theories.
I don't agree. I think whether it's alternative A or B, the state cannot achieve a manslaughter conviction if the jury finds that the defendant was not guilty of vessel homicide, because a finding of not guilty on vessel homicide is that the defendant did not act recklessly, much less culpably negligent, much less intentionally.
Your Honor, I know that only in today's discussion about the jury instructions have I made reference to the State versus Perez case, but I think if we, just even wrote for 5 minutes, it's very, short opinion, but there the defendant was charged both with reckless driving and vehicular homicide. The jury found not guilty of reckless driving, found him guilty of vehicular homicide. So the defense said, well, if the jury said he wasn't driving recklessly, then how can it be vehicular homicide? And the court said that we would conclude that the doctrine of lenity or of jury pardon should apply. There was abundant evidence to support the conviction of vehicular homicide as discussed above. Had the jury been instructed that reckless driving was a lesser included offense homicide, as perhaps it should have been, the result would have been the same, guilty of the greater charge. In this case, it appears that the jury may have analyzed the problem of overlapping charges better than the defense, prosecution, and the judge, and it dealt with it by finding him not guilty of the lesser, but may have sought to punish him twice for essentially the same series of acts. So in this particular case, where the state has charged two separate offenses, rather than charging one and relying on the second as a lesser, the jury should be able to make their own findings as to each charge. And if ultimately, if the jury were to come back guilty on both, okay, then maybe we won't have a double jeopardy issue. If they come back guilty on manslaughter but not on vehicular homicide, I would cite to the Perez case saying it's not an inconsistent verdict. If they came back guilty on vessel homicide but not guilty on manslaughter, okay, and obviously if they come back not guilty on everything, we got nothing to discuss.
Do you think that this should be a special verdict as to either theory on manslaughter?
No.
Okay.
Because just like you don't have to have a special verdict on first
Felony
degree murder
murder
if
and
it's premeditated or felony murder.
Yeah.
However you want to slice it, the jurors can half and half find, there's no basis for a special verdict. This isn't like, oh, we're going to get an enhancement if there's a firearm or something like that.
Okay. Okay. Now, what was that? Give me the citation.
Of course, Your Honor. It's State versus Perez, 718, Southern 2nd, 912. It is a 5th District Court of Appeal case from 1998.
Okay.
Judge, if we can respond to that case.
Go ahead.
So in Perez, the two charges were vehicular homicide and reckless driving, which reckless driving had no death component to it. So the difference between that case and this case is the driver in Perez committed a series of acts which could have been considered by the jury to have been reckless. And the court said the jury, and I'll read the quote to you, in this case, the jury could have concluded that Perez's decision to speed and pass cars in a no passing zone was not reckless, which is why, as to reckless driving, no death resulted from that action. The jury could have acquitted him. But his final decision, the one that did cause death, to try to pass the last car after seeing the approaching van, was reckless. So it wasn't a truly inconsistent verdict, whereas in Mr. Pino's case, both manslaughter, the culpable negligence component of that, and the intentional act component of that, as well as vessel homicide, must be an action that results in death. So if the jury finds Mr. Pino was not reckless, and therefore his quote-unquote reckless conduct did not cause death, they necessarily are finding that a higher mens rea did not cause death. It's different. It's not as if he's charged with manslaughter on count 1 and culpable negligence generally on count 2, whereas they could find, an action of his along the way was or was not culpable negligence, but did not cause death. Does that make sense?
Makes sense what you're saying. I hear it. I understand that.
Right.
Well, first of all, the appellate court is hypothesizing what that particular jury may have done, that they could have said, well, we're going to give him a pass, so to speak, for some conduct, but not for others. But either way, the court right there is just kind of speculating on what the jury would have done, but they recognize that regardless of what the reason was, it could have been a doctrine of lenity or it could have been a jury pardon. It could have been any of those things. And the appellate court still said it's not an inconsistent verdict.
But it under the manslaughter resulting in death, under either theory.
Yes, and that's the other reason why this case assures us that there's no reason for the court to instruct the jury, you cannot find him guilty of manslaughter if you don't find him guilty of of vessel homicide. That there's no basis in the law to instruct the jury that way. Manslaughter we can prove by culpable negligence and or intentional act. Vessel homicide is only with recklessness, and even if reckless is somewhat of a lesser of culpable negligence, reckless driving is a lesser of vehicular homicide. Yet in this Perez case, when the jury came back not guilty on reckless driving, but guilty on vehicular homicide, the court said that's not an inconsistent verdict.
Two important points. One is that the Supreme Court of Florida has specifically said in McCreary, the legislator intended and did create a lesser included offense with a lesser standard of proof required for conviction. There's no doubt the Supreme Court has said that. That's how they've upheld this distinction between the two statutes. Second, in Perez, there was a theory of consistency, and that is that he may have been reckless at one moment in time, not causing death. He may have been reckless at another moment in time, actually causing death. And the jury could evaluate the two scenarios independently. More importantly, the Court of Appeals seemed to say it wouldn't matter anyway, because on appeal, standard of review, we assume the jury acted out of lenity, not logically. Going forward, though, looking prospectively, the court should be trying to make sure the jury does act logically. And to say that it's okay, let's send it in there and we'll let the Court of Appeals justify an illogical outcome seems to be a result-oriented approach that is not what the law should be.
No, but isn't it because there are both theories that the state operates under in making an argument, okay? If vessel homicide, recklessness needs to be proven.
Only recklessness needs to be
Okay.
proven.
Right, okay. And that is in line with what would be the greater offense, manslaughter under culpable negligence, right?
So far, so good, I agree.
But if the jury does not find vessel homicide under only recklessness,
Yep.
okay, that line, why couldn't a jury still find manslaughter under intentional act?
Because intentional is even more serious than reckless and culpable negligence. It's intentional. It was an intentional act to strike the marker, not as a result of just driving culpably negligent or recklessly. So should be the absolute highest level of mens rea. It's like voluntary manslaughter as opposed to involuntary manslaughter. It makes no logical sense. It's not a possibility logically or legally that a court of appeals will sustain it and forgive the jury for acting illogically.
But intentionally committed an act or acts that caused the death. Again, I think is the difference in the intentional acts being the intentional act of speeding or going fast. The intentional act of
It has to be an intentional act that caused the death.
okay.
That's why we had this conversation 2 hours ago.
That's right, we
And
did.
now it all comes to a head
Yes.
because the state is resisting the reality of McCreary, not reality, but the stated position of the Supreme Court of Florida, McCreary, that vessel homicide is a lesser included offense of the manslaughter charge.
But what I don't think is connecting right now is that the state is not relying on that as a lesser included. We've separately charged it so that the jury can make their own finding as to each count, as to each charge in the information.
Okay, so, let me ask this. Could the defense, if they asked for a lesser under manslaughter, could they ask for a lesser of
Culpable negligence.
culpable negligence?
If they wanted to, as a category 2, have a lesser, yes. I just didn't hear them asking for a lesser included instruction.
Okay, all right.
I wouldn't fight against that. If they want culpable negligence as a lesser of manslaughter, no problem.
But that would go back to the instruction that you had proposed as a special rather than a separate lesser crime.
Could you please repeat that? I'm sorry.
And it wouldn't apply because the lesser one isn't included when it's not to be used unless there's a death here, so it can't be a lesser.
But speaking of lessers, there is the original misdemeanor charge that was brought against Mr. Pino, that failure to abide by the navigation rules resulting in an accident or in a boat crash that causes death. We would submit, particularly given now that the jury is hearing navigation rules, that lesser included offense be made available to Mr. Pino.
Okay.
Under manslaughter as a lesser? It's not a cat 1 or cat 2.
Things that would be
It's not a lesser included of,
vessel homicide.
isn't it a lesser included of vessel homicide? Did you check and see? Vessel homicide is 7.9, right?
I think it's characterized as a permissive lesser included.
No, it's not. It's not a statutory lesser. It's not.
Well, Judge, the statute is 327.33.
What's that? I'm sorry?
The statute is 327.33
Right.
under, which is listed here on this table, under reckless driving.
That's a separate charge though. It's not a lesser of vessel homicide, or the state didn't charge it. So it's not a lesser. It's not a lesser
No,
of
but-
vessel homicide.
No, but counsel's right, Judge. 327.33 is the statute that provides the misdemeanor that if a defendant violates a navigational rule without operating the vessel recklessly and death or serious bodily injury results, that is a violation of 327.
Well, that's what your special instruction is. Well, your special instruction talks about navigation. It's 327. Go ahead. Oh, I see what you're saying. Reckless operation of vehicle. Okay.
And under
28.19. As a category 2 lesser. 28.19. I don't think I've ever used this. Let's find it. 2819. 2819. Reckless. Okay, do you want, are you requesting that as a lesser?
I suppose we better confirm with Mr. Pino about this, so we'll do that.
Oh, yeah, okay.
That makes things a little tricky, Judge, because, we need to be able to plan our closing arguments based on what the jury instructions were going to be, which
Yeah,
I
I
thought we
know.
would be
Okay.
able
We'll
to.
do it
So-
today, we'll do it now.
Okay.
If we take a break, we can do it.
Yeah,
No.
so I think I'm ready to take a break.
Perfect.
Why don't you go, let's take a break.
Oh. If your court reporter has one more minute, Mr. Arbolino located where the court discussed the issue of instructing the jury on the personal flotation devices.
Uh-huh.
Yeah, if you want, I can play the video for you from court.
Sure.
Put it on the microphone, I guess. Are these on?
You just put, you want to just, yeah.
We're just to make sure the job. Okay. So this is from day 3 on Court TV on YouTube at 5 hours 11 minutes.
Okay.
Person. What is the law in Florida as to who must wear a personal flotation device? If you don't,
Just saying,
minors under a certain weight.
That was from Sergeant Delgado. I'm not sure if that was also broached with Officer Albert, with Paul Albert.
and I think that was a different witness, right?
Correct, that was Sergeant Delgado, not
It
Paul
was.
Albert.
But the question was, what is the law in Florida as to personal flotation devices? And the court sustained an objection to that question and noted to the jury that it would be
Okay.
instructed.
I'm not going to instruct the jury because I'm not going to do that. I anticipated and knew actually also that that would come out through what's his name, Albert. So,
Okay.
glad you found it, but it wasn't intended at that point at all that I would instruct the jury special, because I knew that was going to be coming up later on.
We'd still request it based on that.
Okay, that's fine. Thank you.
Thank you.
And if you find the portion of when Albert was testifying about it, and there were questions about it, then you'll find in the record that the jury did hear that it is not the law, and in fact there was more detail. Only a person under the age of
6.
whatever details he went into are required to wear a personal flotation device. So the jury heard it without objection through the witness, and so I don't need to instruct them specifically. Thank you. All right, so you're gonna let me know about 28.19?
Yes. Can we recess for
Yeah.
15 minutes?
Sure. Because we're pretty much finished with the instructions. At this point, I think other than whether, well, I need to know that, I need to have him on Zoom basically to let me know about everything in terms of what we discussed on the instruction charge conference today, and specifically on the lesser.
Your Honor, the instruction 28.19
Yes,
is as to 327.33 subsection 1.
okay.
But the provision that they're talking about is 327.33 subsection 3.
Oh,
And so I don't think that there is a standard jury instruction for that offense. I mean, certainly we can craft one if defense wants that as a lesser. But the
Oh, I see.
28.19 is reckless operation of a vessel, which is not the same as violating a navigational rule, but not operating recklessly, and a death or serious bodily injury results.
Yeah, that's the only one that actually makes reference, but it's a different subsection of the statute. But again, if you craft one, and we'll review it, if your client wants that to be included as a category 2 lesser, I guess the question's gonna be, I guess I'll consider that down the road. You know, what a potential punishment would be if a jury came back on a crafted lesser.
Well, it would be a second-degree misdemeanor. That particular subsection is a second-degree misdemeanor.
Okay, well, that's what it was originally charged as, right?
Yes, Your Honor.
Okay. Okay. Because it was you were charged under subsection 3.
Yes.
Okay.
3, I think,
3A.
3A is.
Okay. All right, go, let's take a break. Thank you.
Thank you.
you, Judge.
Okay.
So we spoke to Mr. Pino. Ready to go on the record?
Yes.
Okay, we've spoken to Mr. Pino, and he's going to decline the lesser included offense.
Okay. There were a couple of other things that, I think there were a few other things to discuss with Mr. Pino.
I told him that there were jury instructions that we had requested. He made it very clear he's deferring to his legal counsel because he doesn't have legal training, and so he is putting his confidence in our legal team.
Okay, so I'll get that confirmation, I guess.
We can do it now. He's available by phone, or we can have him go in by Zoom as you wish, Judge.
Okay. Yeah, let him come on Zoom.
Okay?
I have the Zoom open.
Okay.
We just sent them a Zoom. I have a Zoom, but yeah, I'll send it to him.
Can you go back also, just look at,
Oh, you want to put them on our Zoom?
I sent them on Zoom.
I want to make sure, again, because I don't recall a circumstance where I've had a trial where there was a death where I did not instruct on both justifiable and excusable homicide. I don't remember ever not instructing. Now, I understand that you all agree and stipulate, but I don't want this to come back around where it's fundamental error not to instruct when there's a manslaughter charge on justifiable homicide, even if it's not applicable.
I thought I heard you read something that made it sound like it can be waived.
I did read something like that, but I'm just sharing with you the slight hesitation I have, and that's something that I'm going to ask Mr. Pino as well, because should there be, I don't know, I want to make sure that's would be a fundamental issue. And I don't know if you've seen anything on that. I want to confirm it's not fundamental.
I will tell the court, I am very uncomfortable with the court not giving the entire introduction to homicide instruction.
Okay.
I'm very uncomfortable with it. I do think that the defense potentially can waive that, but I think it leaves us with a possibility if something were to happen, if he was convicted, that there could be some kind of post-trial litigation on that issue. I think the safe thing to do is do what the instructions tell the court to do, which is to give in all, it's called introduction to homicide, not...
Okay, I'm gonna probably continue to mull that over. I don't think it's gonna necessarily cause impact anyone's closing argument. Other than if I choose to give the full instruction as part of the standard, I don't want to be in a position where there's potential fundamental error. That's where my issue, that's where I was thinking about while we took a break, even if there's a waiver. And even if I did read something, because it made it seem like it can be done, but I'm going to have to think about that, okay?
Of course.
And over the weekend, I'll probably be sending you all an email to advise you whether it's going to remain in the instructions.
As you might guess, we'll be working all weekend, and if there's a time the court wants to do a Zoom or phone with us, we'll be available at your call, whenever you'd like to do that.
Okay. All right.
And we're getting Mr. Pino on the Zoom.
Okay, good.
He's on already.
So he's on your Zoom.
Yeah.
Okay.
Does that help?
The camera here, do you want the camera pointed at the judge or you? Yeah, the judge.
Oh, okay.
He just needs to turn on his camera.
Oh, okay, good. All right. Very good. Mr. Pino.
Hold on one second, Mr. Pino, we're going to get the
Let's get the
volume.
audio, we'll get the audio set up. Can you hear me? Okay, I can't hear you yet. I'm working.
Hold on, Mr. Pino, we cannot hear you.
Maybe he's on mute.
Maybe no speaker on that.
You know, if Mr. Pino wants to come into my Zoom, he can come into my Zoom. And then,
Can we send Mr. Pino the Zoom address for the judge? What's that to?
Put the volume up.
might just be easier to do that. Mr. Pino, you can hear me, but we can't hear you, so I'm trying to make this easier.
Hold one more second. Make sure you're not on mute, Mr. Pino.
He's not.
No, he's not.
He's not.
I know.
Does the TV have on?
Maybe no volume.
Did we check the TV volume
Your volume.
Just our.
versus the computer?
The computer, the volume in the computer.
I will tell you honestly, the easiest way, give him my Division 62 Zoom, just have him click off of this and click into 62.
I don't have to get
We're
them.
going to text you the
I just
Block.
sent it to
Zoom link. You sent it to him?
Well, actually,
Thank you.
George's number, but I sent it to our group, so someone should just be able to copy it.
I got it.
Via email.
Sorry, Judge.
Okay, that's okay. We'll get it done.
Okay, I got it.
Okay.
I sent it to him.
I sent it via email.
Good.
Okay, I have it now. Okay.
How does he know it's his business?
Go.
Hi, Mr. Pino, are you there? Oh, he keeps coming in and out. Bad
Signed out?
connection. Yeah, he's out. Keeps signing in and signing out. I lost him again. Oh, it's very good. Okay, I don't know if the audio is disabled. Mr. Pino, can you hear me?
Hi, Your Honor.
Hi, okay, good. All right, so I see Mr. Pino, he's on my Zoom, and just gonna ask a couple of questions. Can you raise your right hand, sir? You swear from any testimony you will be the truth, whole truth, nothing but the truth?
I do, Your Honor.
Very well, thank you. You can put your hand down. So we've been going
Thank you, Your
through,
Honor.
we've been going through this afternoon the jury instructions, and we spent several hours on them. And I wanted to confirm a few things. Counsel, why don't you ask your client the questions for me?
Sure.
Okay.
Mr. Pino, can you hear me? This is Howard Srebnick.
Yes, good afternoon, Howard. I can hear you perfectly.
Good afternoon. So we've been here since 1 o'clock. We, your defense team, including Mr. Shapiro, Mr. Armelino, Ms. Klein, we've been going through the proposed jury instructions, those proposed by us, those proposed by the state, and Judge has ruled on our requested instructions, those of the state. and we have informed her that you have told us that you would abide by the advice that we have given you on the requested instructions, that you've deferred to us because you don't have any legal background, and that you were relying on our experience and advice in how to best present those instructions for the court's consideration. As well, we've informed you that there was a discussion about a lesser included offense. It would have been the misdemeanor offense you were originally charged with, which brings a maximum sentence of 60 days in jail. It is not a felony. We discussed with you that option, and that you had advised us that you would not be seeking this lesser included offense at this time, which means that it won't be presented to the jury as an option for them to deliberate about. Did you understand everything I said, Mr. Pino?
I did, Howard.
And do you continue to prefer to follow the advice that we gave you, including declining the lesser included offense instruction?
Yes, I do.
Is there anything else, Judge, you'd like me to ask Mr. Pino?
No, I think that, so the instructions, in terms of any objections you made, any special instructions, they're all adopted by Mr. Pino, and I want to be clear that this would satisfy as a necessary part of the proceedings, an essential part that Mr. Pino actually needs to be present for, even though I did accept a waiver of his presence, because this is a critical part of the proceedings. I wanted to make sure that Mr. Pino understood why we have reached out to him today, so that down the road we have a clear record that Mr. Pino is considered to have participated in this critical part of the proceedings.
Mr. Pino, did you hear the judge?
I heard everything very clearly.
And you recall that yesterday we spoke about the option of you either attending or not attending today's conference, that I explained to you these were legal matters, that the jury would not be here, and we discussed and you preferred to allow the lawyers to appear on your behalf so that you need not attend the proceedings even though you had the option to attend. Is that right?
That is correct.
Okay, yeah, and when we talk about this again, it just, I don't know what the future will hold. So there could not be a claim later on that, that something so important and fundamental that you were not present for, that there was, you couldn't object to it later on, basically, if there was any issues that came up.
I understand, Your Honor.
Okay, all right. Okay, I think I've covered everything. State, do you have anything that that you feel I needed to ask Mr. Pino?
I just want to verify, are there any lesser includeds at all that the defense is seeking in this case?
Okay, so there are no lesser included instructions that the defense is seeking.
One moment, Your Honor.
All right. Just stay with us if you would, Mr. Pino. Thank you.
Of course, anything you need, Your Honor.
Okay. while I have Mr. Pino here, I'm just going to finish up with our charge conference. If Mr. Pino would please stay on our Zoom. And I think I had left off with the one question on whether 3.12D, the legally interlocking counts instruction, would be given. The state had objected, I believe, to my giving that instruction. And that goes back to the argument that was made that vessel homicide is a necessarily lesser included offense of the manslaughter, and therefore, if the jury came back with not guilty on vessel homicide, that they necessarily could not come back on a manslaughter. And Ms. Adams, if you had anything further on that, I don't know if you found any other cases or anything else you wanted to address. I'm going to go ahead and.
I don't think it is a correct statement of the law that the jury cannot find the defendant not guilty of vehicular homicide, but guilty of manslaughter. They are not mutually exclusive crimes. The vehicular homicide is not a lesser included offense of manslaughter by intentional act. Moreover, the state has opted to charge them as two separate counts. So the jury should make a separate finding as to each crime, and even if, under the Perez case, they made a finding or they decided to acquit the defendant of the charge of vessel homicide, they still could lawfully find him guilty.
I cannot hear you, Honor.
I'm sorry. You want to move that microphone up?
Oh.
I'm sorry. No, you can just take the one on your desk and turn it on if it's plugged in. There we go. Okay, thank you.
They are not mutually exclusive crimes.
Because if I understood, again, on the manslaughter, there are two theories of prosecution, which is lawful, which would be the intentional act which resulted in a death, or the culpable negligence. And that, if I understood, that was the state's position as to why they're not, first of all, they're not legally interlocking, and second, why the other requested instruction that a not guilty on the count 2 necessarily requires the jury to come back not guilty as to count 1. It would also impact how the verdict form would be prepared and read, because it would be, they would have to be instructed on, they would be instructed on count 2 first, on vessel homicide, and then there would have to be some statement in the verdict form, which is used in capital cases, where, you stop here if you don't find the state has proven beyond reasonable doubt the vessel homicide.
And that's so distinct from what we're doing here. That's, for sentencing purposes.
Understand.
So, I mean, to the extent that the state made I made a choice in how I charged this, and I want the jury to make a separate finding as to each crime. And even if they were to say he's not guilty of the vessel homicide, the jury still has the option of finding him guilty of manslaughter. And there's nothing to say that that's illogical or not a lawful verdict that the jurors can have. Who knows? Maybe they acquit him on both. I don't know. But what I do know is that these charges were separately filed, and the instruction that the court gives as to your verdict as to one charge should not impact your verdict as to the other. They are
It has to be
separate
treated
crimes.
as a separate crime charge.
Correct.
Okay.
And that jury instruction reflects the law, and I think that what the defense is seeking does not reflect the law.
Okay, I understand. And I understand the defense argument in this regard, and the request for not only the special instruction following the vessel homicide instruction, but also the instruction for 3.12D, legally interlocking counts.
Thank you, Judge. I think this also feeds into the verdict form.
And it's in the verdict form instruction as well.
And so what I'm hoping the court can explain, if not to us, to the jury then, what is the difference between the vessel homicide and the manslaughter charge if the state is proceeding under two theories of manslaughter, intentional being the A, culpable negligence being the B.
But it's an or. It's an or.
Right, it's or, but this is what I'm struggling with, is that intentional is a higher level of mens rea than culpable negligence. So
There are alternative ways in which, by law, the state can prove the manslaughter.
it's almost, I think it's culpable negligence is a lesser included of intentional. Logically. And so, and we know that McCreary has already said that vessel or vehicular homicide is a lesser included of manslaughter. That was the whole point of McCreary. So I'm still struggling to understand how the mere choice by a prosecutor to allege both theories under manslaughter allows them to then avoid what the Supreme Court has said.
I think it depends on, in terms of the evaluation of what intentional act means and how the jury is permitted to evaluate that. The intent to, again, the examples that were given, if the jury finds that the intent to operate at the speed that the vessel was operating at, the intent to go through a point in the channel on one side of the channel versus another, the act of a change of course at some point. Those are the acts, I think, that the phrase intentional act are modifying.
That's their theory, but it could either be...
That's the state's theory,
fine.
of course.
So they defined, however, they want to define the acts, whatever that group of acts are.
Mm-hmm.
Then the question, was it done intentionally or culpably negligently? It's still the same acts. They can't, I don't think one count can charge different acts within it.
Okay.
They have to...
I hear your argument. I understand it. I'm not agreeing with it. I'm going to instruct the jury as requested by the standard instructions. I'm not going to give a legally interlocking count instruction, and I'm also not going to give a special instruction advising the jury that a not guilty, if they should find not guilty on the vessel homicide, that necessarily requires them to find not guilty on the manslaughter.
I understand your ruling over objection. What I think the court has done at the state's invitation is said that vessel homicide and vehicular homicide are not lesser included offenses of the manslaughter by intentional act. That would be the logical conclusion, which I believe is inconsistent with McCreary, having said that that's exactly what the legislature intended by passing the vessel homicide statute.
Okay.
So that's, one
That's
last...
our difference of interpretation
Fair
of McCourt. Absolutely fine to do that, of course, and we have a good record.
And so, can I then, before we call it a day, bring us back to where I began, I still would like to be able to understand how the jury is going to differentiate between the two crimes if the difference under McCreary is that manslaughter has a greater degree of mens rea. It seems to me that the instructions don't accomplish that because they both deal with this conscious indifference. And so, given the court's rulings, I'm going to request again further instructions on the manslaughter to make clear that that's some greater level of depravity, I'll use that word loosely, than the mere recklessness. Otherwise, they sound the same to the jury of the instructions given.
And that was the additional language that you refer me to under the manslaughter instruction that you had provided to me.
Yes, sir.
Now, my ruling is going to stay the same. I will review it again, as I do, over the weekend, and if there's anything that should change, I would certainly notify the parties of that. But either way, obviously it's good and interesting legal argument, and I think some of these matters could be matters of first impression anyway, and we have a good record. Okay. The only other instruction was submitting the case to the jury, and I just, will the jury have a clean laptop?
Yes, I have one reserved.
And you'll make sure that the defense looks at the laptop, make sure it's a clean laptop.
Yep.
And for any digital evidence.
Yes.
Because I don't bring them out if they ask to see digital. I want them to have everything they need in the jury room.
Yes.
And be able to view and listen to all of the evidence. So I'm just in my mind thinking, documents, audio and visual. I want to make sure they have everything they need. So if I'm missing anything other than a clean laptop,
I will also have a DVD drive that can be plugged into the laptop because one of the items of evidence that was introduced was a DVD.
okay, good. All right, because it was in a DVD. Okay. I can't think of anything else.
There may be one other issue that now we have to address, which is unanimity as to the theory of manslaughter. 'Cause
Okay.
now, right, the state is proceeding under two different theories.
Which is, okay, so, right, whether or not there needs to be a special verdict where the jury would have to find unanimous as to either manslaughter by an intentional act leading to the death or culpable negligence. Similar to if we have, I guess, a first-degree murder with premeditation, right?
I've never done a first-degree murder.
Okay, premeditation or felony murder. I think I'm going to think of this as an argument along the same lines because I haven't researched the issue of whether or not with a manslaughter, with the alternate theories, whether or not a special verdict is necessitated.
At a minimum, I think at least a jury instruction that they must be unanimous as to whether it was an intentional act or culpable negligence.
I don't have any case law on that at all, and I invite anyone to find me a case that would require that. In fact, for the request, I'm going to leave it at that. Right now, I'm going to decline to do that, or to create a special verdict form to do that. But if anyone, state or defense, should find any kind of legal authority that would require a special verdict, I would love to see that. You'll see this now in the context of, enhancements. It comes in for the purpose of sentencing. In the cases that you're going to find where there are special verdicts, it has to do with if there would be enhancements for a jury to make. A jury would have to make a special finding for certain enhancements. That's where you'll find the cases that talk about special verdicts. Okay? So if you find anything, I'd love to see it. I've not seen it before, but because when we talk, even it has been a lot of discussion over the years in murder cases over felony murder versus premeditated. And while it continues to be an issue that defense counsel raised, I think the Supreme Court has maintained the position that there is no special verdict for the jury to find unanimously either a felony murder or a premeditated murder. So I'll leave you all with that, and I will see everyone at 9:30. We'll start up 30 minutes. At least we should meet 30 minutes before, and I have coverage, so we'll be good to go.
I will just, I have I think a small table that I would like to bring with me to the courtroom just because.
I can't hear you, Your Honor.
Okay, I'm sorry. I think counsel was going to bring a table to set up in the courtroom, I guess, so that the evidence could be kind of, instead of going back and forth, and I think everyone might have access to it, right? If you bring a table here.
I would share it.
You would share it.
Of course.
Very good. So it just makes it easier to set up any evidence on that table as opposed to coming back and forth to the clerk. So that's fine, and I think that would be fine with defense because we're going to share. Okay.
Judge, what schedule are you proposing in terms of where we're going to break during the course of the closing?
I propose, you think tell me how you think you're going to break up your closing, generally.
I think probably if I would need maybe about an hour or so for my.
I cannot hear her, Your Honor.
I think I would need about an hour or so for my initial close.
About an hour or so.
And then I would reserve about 30 minutes perhaps for rebuttal.
I will tell you, I do not put time restrictions on, I don't do any opening, I don't do any close, I don't do that. So if you're a little bit over, a little bit under, I plan to give you a couple of hours. I think you all indicated you wouldn't need more than 2 hours, but I'm not going to put a restriction. So you're going to break it up, and what I think would happen is after the state's first close, we would take a break. You could then figure out how you want to set up the evidence, and then the jury would come back. You do your close in its entirety, and then what's going to happen is we're going to have to break for lunch at some point. That's probably when we're going to break for lunch, okay? And after you finish your close, we're going to come back, and the state, I'd like to see if we could finish the state's rebuttal close before I break for lunch, but I don't know that that's going to happen.
If the state is about an hour, I think I'll be about an hour, in which case I think we can get them all done.
If that's the case, that's fine, but I don't want to break too late for lunch because I have to have a break for lunch and then instruct the jury. And I need to get them out and instructed, I would say, no later than 2:30, 3 o'clock, and get them working. And I don't tell them this, but I'll keep them working. I'll order them dinner and not interrupt their working until they're going to turn the lights out on us, which is about 8:30 or so. Okay? And at that point, if we don't have a verdict, they come in, I instruct them, and they come back, and they go right back into the jury room the next day. They don't even see us. They're just taken right back into the jury room by Renee. And this, in fact, this courtroom is, while the jury is in the jury room, no one's permitted in the courtroom, except for Renee. And the clerk could sit here, and Vanessa could sit here, but no parties, no spectators. The room is clear. And so, you know, once they start deliberating, we're not going to have anyone in this courtroom unless there's a question, and we'll all be in the courtroom, and or we have a verdict. Okay, so no one is in this courtroom at all. So if you're going to have, we'll talk about that, but you'll take things out with you that you need to take out with you because you're not going to have access to come back in.
So I've got a question with the essentially equal time being provided to both sides in the closing arguments. So I appreciate, as a litigator, that the court does not impose a hard cutoff, but I just want to be clear for our purposes, for our planning purposes. If, for example, Ms. Adams were to take an hour for her close, and then we took an hour, 15 minutes or so, the prosecutor's final close, or rebuttal close, it seems to me there should be at least some restriction, you know, to provide at least fairly equal time between the parties addressing the jury.
Okay.
I'm just wondering about that.
Well, let me say this. We have to be reasonable, okay? You know, if you're able to consolidate your close in an hour, and they've taken an hour for the first close, I'm not going to deprive the state of their opportunity to come back with a rebuttal close. That's what the law allows for. And if it's 30 minutes rebuttal that they're asking for, then that's not unreasonable.
Well, I agree that as long as the rebuttal is, you know, not more than, let's say, 50% of their opening, I'm not going to complain that they've exceeded how much time I use. But
Listen, I understand, but I play it by ear also, and I give the state a fair chance to rebut because the rules allow for it, and they get the last word because it's their burden. So I would give them a fair chance to rebut, and I've not had any issues about this that I can ever recall. I think we could all manage it fairly well. What's fair? They're going to have a chance for a rebuttal close to rebut your closing. So, and if you have any concern, then you should raise an objection, and I will handle it accordingly. I will either say sustain the objection, or I will overrule and let whoever's doing the rebuttal close know that you have, you know, start to wrap it up or whatever my comments might be. Because I'm obviously going to listen very carefully that it's truly a rebuttal close, right? So, I think we're good on that. All right.
Last question, just
Yes, sir.
logistically. Once the jury begins its deliberations, is the court going to require that the parties remain here in the courthouse, or will we have a...
Just you're going to give me all your information, and you're going to be on call. And, you know, for questions, you have to be accessible. I've done it at times where we've done it via Zoom. You know, I don't, the questions, I don't bring the jury in generally to answer questions. They'll come in a note. I'll get the parties together. We'll decide what I'm going to respond and how I'm going to respond in the note, in a handwritten response, and that goes back to the jury. Kind of have to play it by ear depending on what their question or concern might be, if there is one. You know, you're free to do what you need to do. Just you want to be within a reasonable time to be able to access either the courthouse or Zoom to answer questions.
Thank you, Judge.
Okay. You all have a good couple of days, and I'm sure we'll be in communication. See you 9:30. Thank you.
Thank you, Your Honor. I truly hope you have a nice weekend.
Okay, you too. Thank you.
Thank you.